please be seated. Thank you, folks.
Safety.
All right, Your Honor, the matter before the court is Commonwealth versus Shawn Johnson. It's docket number 2022-268. Counsel for the Commonwealth and Mr. Johnson, please identify yourself for the record.
Good afternoon, Your Honor. Jennifer Blair for the Commonwealth.
Okay, good afternoon.
Good afternoon, Your Honor. Rosemary Scapicchio on behalf of Mr. Johnson.
Okay, good afternoon. Mr. Johnson, good
Good
afternoon.
afternoon, Your Honor. Joseph Calvi on behalf of Bianca Ciancio, whose appearance was waived today.
Attorney Krosky on behalf of Giovanni De Los Santos. I think that case is also calendared. They're co-defendants.
Right.
I know Mr. Johnson has something specifically before you.
Correct.
I expect my client here, I don't know if his appearance was excused. It very well might have been. There's been some last-minute changes of location. I did just send a text out to him, but nothing to hold it up because I know it's Mr. Johnson's day right now.
Right. Okay. Before I forget, I did get a call from Judge Krupp asking me to schedule you guys for your next hearing, and I think to advance it for a pretrial hearing. He was looking for September 29th, 30th, or October 1st at 2 p.m. So I don't know if the parties are available for any or all those dates.
29th and 30th is available for the Commonwealth.
Okay.
Want him to sit there?
I can't do the 20th, 9th, or the 30th, Judge. I'm leaving for Europe for 10 days.
Okay. So 28th you can't do?
The 28th I could do.
Sorry, you can't do any of them.
I could do the 28th. I leave the
Right.
20th.
The 29th, I'm sorry, the 29th and the 30th and the 1st are the dates he gave me, so.
I'm there the 28th. Can we?
I don't know if Judge Krupp is going to be there.
Oh, okay.
I think
29th, 30th,
I
1st.
can tell you I know he will be there because I've got 5 cases on that day. 2 are in front of him that are scheduled for motion hearings, and knowing what I know about him and how he likes to keep his schedule, I haven't heard otherwise that those cases are being moved.
Okay.
And Judge, I'm happy to reach out to Susan Irwin, who's the clerk, and see if he'll agree to the 28th. And if he doesn't, we can just select another date.
Okay. So why don't you do that? Get in touch with the clerk ASAP because he has asked, based upon his schedule, that that pretrial hearing be advanced. So do that, and I'll advise him that the party's going to do that with
Thank you.
Assistant Clerk
Thank you.
Irwin. Okay, good. So as to what's happening, I did receive the affidavit from, is it Attorney Miller? Is that who it was?
Attorney Miller, Your Honor. Attorney Miller did ask for a Zoom link. He has he had a surgery and was unable to physically appear, but he's available by Zoom.
Okay. I don't know if we have.
I don't know if he is.
He's not logged in.
Okay. So we haven't given him the link though, have we?
Yes, he's been provided with the link, yes.
Okay,
Yes.
so he's not here right now. Okay, so in terms of where we stand, I know we have the affidavit from Attorney Miller, which essentially, my understanding is saying it's way too much work for us to do what was asked of us. That's in doing it in the context of putting it into as I suggested, putting it into some sort of digital format. And then the second reaction or response was we could do a rolling, I don't know what that means, but we could do a rolling production of some sort, given the documents that are being sought. Attorney Scapicchio, what was your take on his?
So when I read the affidavit that said they couldn't possibly do it, first of all, they're part of the prosecution team. They don't get absolved of doing their job because it's too hard. That's my initial take on it. My second take is I filed a motion today because I've been thinking about this, Judge, since last we appeared. I spoke to probably 10 or 15 experts since last I was in front of you to try to figure out if I could file a motion for funds to get an expert appointed. The problem is that the lab data encompasses so many different specialties. There's DNA, there's fingerprint, there's, paint experts. So it would have encompassed a number of different experts, none of whom I could find that were willing to go through individual boxes predating 2013 if we couldn't get this digitized. So I moved on and I started speaking to law firms about potentially becoming special masters in this case. I think this is a massive undertaking. I don't know that any one person could do it. I spoke to Todd and Weld. I spoke to David Meyer. He was interested, but wasn't going to sign on unless the court thought it was something that was appropriate. But what I wanted a special master to do, and I wanted you to consider, is have a special master sort of get their arms around what's here, and what needs to be evaluated, and then maybe give us a path forward of how to index and document and disseminate the information in a way that makes sense. Because I don't think the court can, I don't know if the court can figure it out. I know I can't figure it out, Judge. And I've been working on it pretty consistently for 6 weeks, trying to figure out the best way to handle this. And I think involving individual experts that we're going to have to pay to look at the same material over and over again, I don't think is going to be cost effective for anyone. So I thought that potentially presenting a scenario where the court would consider appointing a special master in a firm like Todd, it doesn't have to be Todd and Well, but there's certainly a firm that I spoke to that said that they'd be willing to entertain it. Many other firms were not. I can tell you that unequivocally. The bigger firms want nothing to do with being a special master. But Todd Mills has done it before in the Annie Dukin case. I think they've done it a couple of times for different investigations that had been ongoing. So I know they have the capacity, and I know they have the ability to do it quickly and efficiently. And that's what I filed a motion today. I spoke to the Commonwealth. I don't know that they're opposed. I just gave them my motion today. So I'm not asking them to respond. I'm just asking for you to consider whether or not this is the most appropriate way to spend whatever funds we have, to be able to find a path forward that makes sense to everybody.
Okay. We hear from the Commonwealth.
Your Honor, as Attorney Scapicchio just said, I did just receive this today.
Yep.
I would like some time just to kind of digest this motion, and think about it. I can't really commit to a position at this time, but the Commonwealth agrees it is a huge undertaking. It's a massive amount of information, and based on this affidavit, it does seem like, based on how some of the nonconformities were recorded, be it in circling items or putting initials that, would be difficult to discern unless one was familiar with the person's name and the original analyst, it does seem like this is something that needs to, will take a lot of work. And
let me ask this question: in terms of the experts that you're concerned about that are in your case, in the documents that have already been produced from 2013 to present, have there been any nonconformities that are of substance that would be admissible?
I am investigating some, yes, Your Honor.
Okay, and you think they would be admissible?
I haven't fully investigated. What I have is a chart that says this is what happened. I don't necessarily have the underlying data. That's one of the things that I'm looking for, is the underlying data for each individual nonconformity, so that I could make that determination as to whether or not they're going to be admissible. And I don't even have at this point who predates 2013, because my position at this point, having understanding better what the lab consists of, is there might be a real challenge, whole lab challenge, to the quality of the work coming out of the state police lab based on what I know. And what I know, I think I've submitted to the court. I've asked for some additional documentation on the state police lab. I've been in touch with Attorney Dave Nathanson, who I think is in the court today. He is working on a case where actually John Twomley did make a whole lab challenge to the lab during a homicide case. He was working with different state police lawyers and our analysts. They had a little different indication of what was available and what was searchable. And so I submitted his affidavit. He's here if the court has any questions for him. But he is essentially saying that there's another layer of trouble in this case, which is that some of either analysts or lawyers, I don't know who, indicated to Attorney Nathanson that some of these nonconformities have been destroyed in some purging of the documents. We don't know what that looks like. We don't know what got destroyed. We don't know if there's backups, but we know it just keeps getting bigger. What we need to look at just keeps getting bigger. And so I'm trying to, in the way that I can, put my arms around everything that I'm capable of getting access to now, and then hopefully being able to get access to other things. Like, for one thing that Attorney Nathanson's affidavit says, that he found out that there was a quality assurance unit that can identify which employees have corrective actions or nonconformities, and they can identify which employees have transferred, but not for the reason for the transfer. And they have this Qualtrics database that's used for quality assurance. It's separate from LIMS, and it's the way that they keep track of the nonconformities. And so at a minimum, we should be able to get somebody to run that through the analysts in our case and be able to at least catch up to what they already said they would do for Attorney Nathanson and his client, because it doesn't make sense that they could do it in one case and not another. And then the other thing that I have some concerns about, Judge, in terms of this purging, is the other thing that I learned from Attorney Nathanson. I had filed an original motion looking for information regarding grants that were given to the state police lab. I agreed at the last hearing to put that on hold because we had too much to deal with. What I've learned since then, Judge, is that, and Attorney Nathanson was able to develop this, that the grants that the state police lab had required them every single year to list any nonconformities. And so there's another place that we can look for nonconformities. And
well, that sounds like an easier area to, assuming they complied with the.
If they did, I don't know if they did or they didn't, but I'm saying it's a path that we can get some documents so we can start the review. I know we have a November trial date. I don't think anyone thinks that that's realistic given what we're dealing with right now.
That's, I think, what Judge Krupp wants to talk to you about, because he's intent as he sits here now to go forward on that, unless there's a good reason not to.
Yeah, I don't think that that's going to happen, Judge. I really don't. I'm
not making any.
But besides that, Judge, that's what we're dealing with now. And so I'm trying to, while we decide whether or not we want a special master, and the special master doesn't just help us, it helps the Commonwealth. I mean, this is the Commonwealth's burden. It's not my burden at all. But I'm trying to figure a way out of this that it's not going to take us 3 years. Because their affidavit seems to say 800,000 cases, it's too much, it's too hard. And opposition, right, it's a Rule 14 obligation. You don't get to say it's too hard and walk away. You're a member of the prosecution team. You have to figure out a way. And so maybe it gives us that path to say, this is how we should best evaluate it, analyze it, categorize it, and disseminate it.
Right. So, well, and that again begs the question I asked earlier, which is, you know, in terms of lapse of time and how important that is in terms of the, I mean, I understand if there's a motion for a new trial that maybe happened back in 2010, it's much more relevant. I'm not saying it's irrelevant to you, but, you know, the passage of time is going to affect admissibility, especially if nobody has if somebody doesn't have a history of any other nonconformities in the interim.
So I understand what you're saying, Judge. So one of the first things that Congress should do is tell us, when did each one of the analysts in this case start working at the lab?
Well, absolutely, and that's what I was thinking. That was one of the things I was thinking about is, you know, when did these experts start working here? And that's a cutoff. But it's not, Judge. If I want to do a challenge to the whole lab, it's not a cutoff. Because if I want to say the whole lab can't be trusted, then I need the whole full idea of what the lab was all about to be able to make that challenge that none of this information should be admissible. One possibility is that you could do that with the documents you have. With the documents from 2013 moving forward, that would be a good thesis to start with. And if you start hitting, you know, if you start identifying significant information that suggests the lab lacks reliability at the time that your client was faced with all those evaluations and experts, that makes sense. And you have other ways to maybe even test some of that information. Like you said, there are other options here, such as the grants. And yes. So you have other ways to kind of test whether you're getting the information during that period of time. And then once you've done that, and if you've established some sort of pattern, then it makes sense to maybe take the next step towards. And I understand everything you're saying, Judge, but I'm going to be a little suspicious here and say, what if there was a reason 2013 was the cutoff? What if something happened prior to 2013 that we don't know about right now because there's no digitized copies that causes them? I mean, why 2013? When was your client, when are the allegations in your client? Those 2022, is it? No, 2021, I believe, Judge. 2021. Okay. So still there's a substantial, you know, period of time between 2013 and 2021. And I guess that's kind of not what I come back every time, but it's certainly a factor to consider. And I'm certainly willing to do that, Judge, but I think we need more information. I think we do need now the information regarding the grants. I think we do need now the information regarding this other database. I think we do need now the information regarding what was thrown away, if it's thrown away, or what was purged, I think is the word that they used, so that we can have an understanding of how it happened, why it happened, and what the universe looks like without that information. You're saying there were documents purged post-2013? Or you don't know, or is it pre-13? Dave, do you know if it was post-2013 that anything was purged?
So, as I represented in my affidavit,
this is David Nathanson on the record.
Attorney David Nathan. So, as I represented in my affidavit, there were the documents that I understood to have been purged were pre-2013 documents that were purged in 2016, and then additional pre-2013 documents were purged in 2018.
Okay. So that might be relevant to someone. I'm not saying it's not relevant to you, but it certainly may be relevant to people who had cases during that period of time. It's a whole mess by itself.
Or if the analysts worked there in 2013.
Right. So I don't know any of that information yet. So I think your suggestion of talking to the analysts, now I know there's, it appears to be many analysts listed here, but there's going to be a group of analysts, a narrow group that are important to the case, not just every analyst that walked by the case.
And the CVs of each analyst have been provided, so that information as to when this started.
I mean, that sounds like if the CVs have been provided, that you should be able to glean some, if not most, of that information from the CVs as to when they actually worked for the lab, and that would be a starting point right there. So that's my suggestion: is you take a look at that.
Sure, yeah.
And identify that. Then, let's just go through this in terms of the quality assurance. I'll call it the quality assurance group, whatever that is. Do you have any information about that at all?
Your Honor, I don't even know what you're referring, like which document you're referring to.
Well, I'm referring to just something that Attorney Scapicchio mentioned, that there's a quality assurance group that is that records or identifies some information, such as when people are being transferred out of a particular group. Did I misunderstand you?
No, that's what the David Nathanson affidavit says. Do you not have?
I don't have that.
Oh, I'm sorry. I thought I handed it to you this morning. I apologize.
So this is part of. I mean, I know in the criminal world, I've done a lot myself. Is that doing this last minute is not helpful to the hearing, and I'm not suggesting anybody did anything wrong. As much as for me to process information, for you to be ready to respond, some of this could be resolved in advance. Or you'd be able to respond to it. But
just so I can respond, I'm responding to their affidavit that was just filed 2 days ago. That's what I'm responding to. They literally filed it 2 days ago. I'm catching up to what they've known.
So it starts someplace else other than with the defense. I understand. But again, not casting stones as much as trying to do things further in advance so we can address this. We have a hearing. Trying to get that done in advance so the parties can respond. I know everybody's busy. I get that. But the things you want to take a look at, obviously, are this quality assurance group, whatever it is, kind of explore that, what their function was, when did they exist, do they still exist, and then what type of information do they have, and is it relevant to this case? So that's one. And that's in David Nathanson's affidavit in terms of the identification of what that group is. I don't know if it still exists. So that's one. And then this question of purging documents, which appears to have occurred later on. And that might be relevant to Attorney Nathanson's case, which is a different case, and maybe, I'm not saying it isn't, maybe less relevant at this point to Attorney Scapiccio's case. So it's worth, reviewing that as to whether or not documents regarding pre-2013 were purged, why, and, what cases did that occur in. And then the third issue or source of information appears to be the grants. Grants they received, which, according to what we're hearing, require them to identify some of this corrective action. And this is all state police related. I don't know who in the state police is a point person other than Attorney Miller, who's not on right now, to discuss this with. But that seems that's one of the things we need to do, long term and short term. Is there what else? And then the question of whether or not there's a better way to get information from pre-2013 is to some degree, I think, tabled until we can find out from Attorney Scapicchio whether or not she has experts that reach back that far and what their role are in this case. Because if their role in this case is not substantial, then reaching back to 2013, other than your argument about the whole lab.
Yep.
But I think that can probably be done from 2013 to the present, because you have a 2021 case. You may have other cases where they go, it may be important, but in this case, at least my first reaction is that that's less important here or less relevant. So I think the issue of digitizing or getting all that information from 2013 and before is something that could be put on hold until we get the information from you as to whether or not your experts reach back that far and who they are.
Yes, Sean.
And that shouldn't take long.
No.
And then if there's one person, we can make a determination as to whether or not, the weight of the evidence compels us to take that second step, which is then to do the pre-13 analysis, or not. I can't.
And then, Judge, the state police suggestion that they do a rolling discovery.
Yep.
I'd ask that they at least give us what they think they can give us at this point, so that we can.
I don't have any problem with that.
Okay.
I don't have any problem with that. And then Judge Krupp can make a decision, because I'm sure you're going to file a motion to continue the case for multiple reasons, and Judge Krupp can rule on that as to whether or not he thinks the 2013 documents are necessary for you to go forward in this case. I can't make that decision right myself, although I can rule as to whether or not I think that information is relevant to your case. Absolutely. But you're going to have to provide me with more information.
I can do that, Judge.
Okay. So anything else that we need to deal with today?
There was a protective order on some Proctor information, Judge, that I can't speak for co-defendants, but I can tell you that the only objection that I have to it is because my client is the only one in custody. I'm asking that paragraph 4, which is the defendant's access to items, be amended to allow my client to have a USB drive dropped off by the state police to the Norfolk jail with this information on it, so that my client can access it but not print it. That's how he got access to all the Proctor texts, the Proctor photos. We dealt with Lisa Beatty from the DA's office. She's the one who put everything on a USB drive, who had a state trooper drive it down to the Norfolk jail, and we worked out a mechanism in which my client would have access to the information and no access to print the information. And that...
It's not just printing the information, not sharing it with
anybody. Well, he's
right.
bound by the protective order.
Right.
But to protect everybody, he can't even print it. So it's not like he can print it and hand it out to anyone. He's not able to do that. And I don't know what this information looks like. I thought we were getting something today in court.
I have it, Your Honor.
Okay.
I have it.
So to the extent that it exists, Judge, all I'm asking is that my client be able to view it on a USB drive, just like he did all of the other Proctor information, and it be kept in the custody of the Sheriff's Department until such time as Mr. Johnson requests it, and then they allow him access to it.
Any
Your Honor, I don't have any
concern about that?
I don't have any concern, but what I would like, from what I understand, the protective order that counsel is referring to regarding the thumb drive, there was an initial protective order for the information, and then there was a separate one for the thumb drive that was drafted in order to protect the actual thumb drive and what could be done with it. None is on this order because I'm just hearing about this today. So
no, he's in custody. So I mean, in terms of his access is not a surprise, but
sure. But I would just like the opportunity to draft the order the way.
Draft another order. Come to an agreement. Draft an order. Send it to me, or and I'll sign it.
So that order? That
one
order
you just passed up.
The one I just passed up that has the docket number 0268 circled, that pertains to Mr. Johnson. Attorney Cataldo signed the one that pertained to Mr. De Los Santos, and that one is all set, and Attorney Cataldo has the information. So each defendant has its own protective agreement.
Okay.
So the one that's 0268, that pertains to Mr. Johnson. If Attorney Scapicchio wanted to sign that one, I could give her, I have a copy of all of the information to give to her. I'm happy to get another version for Mr. Johnson with its own protective order and provide that as well. I just didn't,
Oh, you just don't have it now?
I just didn't know about it.
Why don't you do that? You just have to sign a second order, that's all. That we
As long as their agreement that the second order exists and nobody's going to object to it. Because I would object now if they're going to object. I don't want them to.
Well, they're not objecting to it. They're saying they'll provide that information based upon what you've just relayed, which seems reasonable. And it's just a matter of getting her the protective order. If there's language that you're fighting over, or words you're fighting over.
The only paragraph, I have the protective order, Judge. I just printed it out, and the only paragraph that I would object, well, first I asked the Commonwealth whether or not any of the information we're getting today is public, are public records, and they don't know whether it's public records. So
I'm just getting it today from the state police.
I know, but I hesitate to agree to keep records secret that are public records. There's no need to keep them secret if they're public records. That's number one. Number two, paragraph 4 requires me to sit at a jail and go through all this stuff with my client, which I don't want to do.
No. I think what I just heard is that Attorney Blair is willing to go along with the protective order that you just said, with the clause that you just said.
Yeah.
But she has to go second.
Sure.
So that's all. This one applies right now. You
Okay.
can't have it, but there's going to be a second order, which is going to pertain specifically to your client. It's going to have the language that you just requested.
Yes.
And if there's, like I said, if there's some dispute about that, which there shouldn't be, but if there is, bring it forward to me and we can do a Zoom hearing or whatever we need to do, and I'll hear both sides and make a decision. But I don't suspect we're going to get there. So with this here, this is for you to sign. You'll get that information now. As to whether or not this is public information, if you find that it's public, you can file a request to have that carved out from the protective order.
I would just say they shouldn't be filing a protective order for public information.
I agree, in terms of, she can wait, we can wait till it's dispersed, we can put a hold on it, and she can make a determination as to whether or not it's public or not later.
Attorney Carly from the state police, who has provided it to me today, is here if the court would like to just ask him the question. Otherwise, I'm happy to figure out all the information and give the documents later. I just was trying to do it as quickly as possible.
No, I understand. I don't think this is, I don't particularly think this is an attempt by Attorney Blair to sandbag anybody. I think it's just trying to get you the documents and being careful. So we can have the state police representatives, tell us whether or not any of these are protected or public records in her opinion, and understanding, and that's fine with me.
So,
do you want to bring her up?
the approach, Your Honor?
Yeah, please. Or he. Sorry.
Good afternoon, Stephen Carley on behalf of the Department of State Police. The short answer is no, these are not public records. These come from a former Trooper Proctor's personnel file, and those are specifically exempt under the public records law.
So do you have any questions?
No,
Okay. So I'm satisfied that those are protected records. Again, if you find something that you disagree with later on, you can always ask for a carve out.
Yes, Your Honor.
Okay, so those are set for now. She needs to sign the attorney, yeah.
Just for the record.
And you can file those over in Norfolk once you're done.
Oh, okay.
Yeah, because I don't have the file here.
Okay.
Just for accuracy, I think it was represented mistakenly that Attorney Cataldo signed on behalf of Mr. Dela Santos. I represent Mr. Dela Santos, Attorney Krosky. I plan to sign it today to get the information.
Sure.
Just reserving rights that at some point there's got to be a modification, if not a complete vacating of all of these protective orders. So I just don't, I'm signing it for now to expedite getting the information, but reserving rights to seek by written motion modifications and potential vacates of all the orders.
That's on the record and understood by all the parties. But that will be done with a court order. So I think we're all set there.
Thank you, Your Honor.
Attorney Scapicchio just has to sign that, and she can get her documents, as well as I know Attorney Krosky needs to sign his to get his documents. Okay, so we're going to hold the motion for appointment of a special master under for another day, and I think we should proceed as what we've just discussed. I can issue a short order if necessary, but
So Judge, can we just have a time limit on when we're going to get the information so that we're not 3 months out and we still don't have it?
Right. I don't know. What I'm going to ask is the Commonwealth to, within, by Friday, do your due diligence. Today is, Wednesday. Maybe by next Tuesday, give us a little more time to reach out to people and get a sense of what it's going to do in order to get this information. And then you can file a motion.
The information in the, motion that was filed today?
The information we just,
Supplemental?
yeah, the quality assurance group information.
Okay.
Information regarding the purging of the pre-2013 documents, and the grants, whether or not the grants have this information, and regarding any sort of transfers. What else were you looking for regarding the grants?
Apparently, according to what
Corrective
Attorney Nathanson
information?
said, is that every year, that the grant is in process, the state police lab has to assure them or notify them of any nonconformities.
Is this part of your supplemental motion?
Yes.
Okay, so let me just take a look at that. Okay, I don't see it.
It's called Defendant's Motion for...
Additional discovery
Additional
related
discovery.
to, yeah, blah, blah, blah. Okay, so, yeah, I see that, but in terms of the specific information that we're talking about here in the sources of the information, I don't see that that's contained in this motion necessarily.
Maybe it's in my affidavit, Judge, I don't
Is it
remember.
a Qualtracs database?
Yes, that's the database, Judge.
Is that the database you're referring to?
Yes. And that's my understanding, Judge, is that that database is separate and apart from the LIMS database. And that's
That's the quality assurance database.
the quality assurance stuff. So quality assurance, my understanding, happens when something goes awry, that they have to make sure that they're complying with whatever they need to comply with. And so there's a quality assurance database that has the Qualtrics capabilities, Judge.
And do we know when this was first created or established? Attorney Nathanson, do you know?
Do you know when the Qualtrics was first established or created?
I do not, Your Honor. I know it exists currently, and that's...
Currently exists, okay. So I'll issue an order on this, and I'll give you a timeline to respond. And again, as I've said, if you're having difficulty responding, file a motion to, expand on the date for compliance, and then we can go from there. But I think, giving you, till next Tuesday, not to respond with the information, but to tell me what sort of timeline it might take for you to produce this information is what I'll be looking for.
Okay. And then, Judge, I'm going to ask you again, would you retain jurisdiction until we get this straightened out, or?
I'm gonna keep jurisdiction over these narrow discovery requests.
Okay.
But at some point, it may be Judge Prupp or somebody else, if there are going to be questions of continuances, questions of
Understood, Judge.
of sanctions that, if you, because you're going to have to file separate briefings and motions.
Yeah.
If you're seeking some sort of dismissal or something like that. I'm not retaining jurisdiction over that, but just over this discovery issue.
Thank you, Your Honor.
Attorney Blair?
So, Your Honor, will the court be in its order, delineating the exact things to be asking about, because all of those things are not mentioned in this motion?
So I'm going to do my best to identify, based upon this hearing, what I think is appropriate, or if you want to file a supplemental discovery request that specifically identifies it, based upon our discussion, what you think is appropriate, that might be easier.
Sure, Judge.
And then I can take a look at that, and...
We had this conversation. We just had this conversation outside, and we didn't have this response, so...
Right, so
That seems to be a mystery.
that would be my suggestion, and I can incorporate that into a short ruling.
Sure, Judge, no problem.
Okay, thank you.
Yep.
Anything else? Attorney Krosky?
Yes, Judge, where you are retaining jurisdiction over this issue related to the corrective action database, I know on behalf of Mr. De Los Santos, I'm entitled to, any exculpatory evidence, anything that this yields. But I also need to get a filing in on my own client's behalf. I don't want to completely be on the sidelines, because that is not protecting my client, his interest in the record. So, but this limited issue, right?
Well, you share all the same experts, correct? Or do you have...
We have separate experts,
You do.
but I should send pleadings that are germane to this one issue to your attention, not to Judge Crops.
Well, they should all be filed, you know, in Norfolk. Yeah,
Courtesy copy here,
and then you,
courtesy copy.
yeah, and then copy me. I'll take a look at it, see whether or not it's something I think falls within my purview here.
I'm not going to be looking for anything unique or that probably goes outside of the four corners of Attorney Scapicchio's pleadings, but it's not good practice to have a silent docket on this issue.
No, I
just didn't want to interfere and derail something that was underway, but I am going to file something, just so you know, it's folder to preserve the issue for my client.
Okay, good enough. I'll look for your filing, Attorney Scapicchio.
Yes, Your Honor.
Send me a copy. And
I also have two other filings. One's a motion for funds, even though I'm privately retained. It's got the attached affidavit. There's already been a determination of indigency.
Right.
I don't know if you're comfortable.
I can rule on it. Do you have it? Do you have it with you, or
That was filed, yes.
is it one of these?
And I also have a motion to vacate GPS, but that might be more beneficial advancing it and doing it in Dedham, because I just served it on the prosecutor, and I think the probation officer in Dedham has a lot of helpful insight with the struggles and the hardware problems my client's been repeatedly experiencing.
I think that's a Judge Krupp or Judge
Right.
Doolan
I'll
issue.
try to advance it before that 28th date and line that up with the clerk and the prosecutor.
I'm just looking for the,
You can look at it, see what your position is.
okay, that's the GPS issue here.
Come to the motion.
We'll try to get it in before the 28th. Okay. You have a packet as well.
Yeah, he does.
Okay, so that motion is allowed. Motion for GPS, that's gonna be considered by somebody else. I'm not even gonna keep this because I don't think we need it. Okay, good. So I look forward to
So, Judge,
seeing,
just so it's clear, I'm sorry, hold on one second. In terms of the motion that I filed, I think on page 2, I do talk about the Qualtrics database, and a request that they utilize that in this case at the top of page 2. I'm happy to put it in another motion if that's helpful to the court. But I tried to take from Attorney Nathanson's affidavit and tried to summarize for the court what I thought was important.
well, I can also just issue an order, and if you think you need something supplemented, and I think it's appropriate, I can
Sure, Judge, that makes sense.
consider that. So why don't I do that? And then we'll go from there. If you feel something is overly burdensome, you can file something, you know, that's, you know, that objects to that also. But let me just issue an order, and we'll at least start
Thank you, Your Honor.
it. Okay? Thank you.
John, I'm just gonna send him back on the no date. You guys can figure out the date on the Norfolk County, okay?
Correct. They'll do that in Norfolk County.
Thank you, Your Honor.
Thank you.
Madam Clerk.
Thank you.
Thank you, Honor.
John, I think this is the one I filed. I don't know how many you have.
Low dated.
You'll just draft the other one? You'll talk to, Lisa? Okay. Okay, perfect. Yes. Yeah.
Hello. Hi. All right, we're done for the day on the Zoom. I have the Aidan Carney motion to dismiss. How you doing? My name's Grant Smith Ellis. Now, if you missed that Proctorgate hearing, that was just V1. Proctorgate V2 is tomorrow at 9 a.m. Hey, how you doing? Good to see you. So if you want to know what happens there, we're talking about two distinct things. A special master for state police crime lab data that both pre-2013 and after 2013 that the state police are saying it's too much work, they can't do it. And Judge timing, they got all mad when I quit the Zoom. The state police lawyer for that part of the hearing was just not there. Okay? He was just not there. Now, the second part of the hearing has to do with Michael Proctor's data. There's different subsets of it. One of the pieces of data that the state police they turned over a bunch of new material related to like the cases Proctor investigated, etc. They're objecting to giving Rosemary everything she wants. But the stuff they turned over, they want under protective order, just like Proctor's messages. This is separate from Proctor's personal phone. This is like material about cases he investigated, etc. and more. And so it's two bifurcated issues. Judge couldn't even hear, we were supposed to hear that issue about the crime lab, the motion about the special master. I think it's a little odd that the state police lawyer for the crime lab just didn't show up when that was like the most important part of the hearing. So judge was like, well, I can't really hear this per se. I can't hear this right now because how am I supposed to hear the motion when the lawyer for the crime lab isn't here? And what's weird was, and I'm sure some of you heard this and may have caught this in the beginning, judge was like, well, you sent him the Zoom, right? And Rose was like, yeah, of course, Judge, I sent him the Zoom. And then the prosecutor was like, yeah, we sent him the Zoom. And then clerk was like, yeah, we made sure he got the Zoom. And then one of the lawyers for the Norfolk DA was like, well, Judge, he just had a surgery. And then the prosecutor was like, yeah, Judge, I don't know what's going on. As soon as Rosemary dropped that motion for a special master, and she was suggesting David Meyer because only Todd and Weld would do it. And she was suggesting David Meyer because he did the Annie Ducombe case. He's doing the Enrique Delgado Garcia case. And then the lawyer just doesn't show up for the crime lab. His argument before was it's too much work. So Rosemary's like, we'll use a special master. And he just doesn't show up at the hearing. So so folks, I'm starting to see this. There's this quality control assurance unit at the state police, and this might be an Annie Ducombe level scandal because they don't want to turn this stuff over. It's related to Proctorgate because it touches on the cases he investigated, but it might be its own thing. All I know is that was weird. Now we're going to take a listen to the Aidan Carney motion to dismiss denial. By the way, for those of you just tuning in, I want to thank you all so much. You have helped my little book. My name is Grant Smith Ellis with Towel News. You have helped my little book. I can't believe this has happened. Boss Tweed Days in Norfolk County, The Rise and Fall of Michael Morrissey's Machine, reach like the top 40,000 books on all of Amazon. There's a lot of books on Amazon, and this is incredibly humbling. So a lot of you have been asking how you can help. Now, of course, the book is available for free. You can just get the book on my social media. But if you want to buy my research about all of this, God bless all of the people who were impacted by this chaos and all of the people who have suffered. If you want to understand more of it, see the primary sources. I've written a book. So we are going to read this motion to dismiss, but I just want to plug because I do think this is incredibly touching. Now, I bought it for my Nana. I bought it and then sent her the copy. She couldn't figure out how to work the Amazon. So I actually can show you now what it's like. I didn't realize I could buy it. I thought it only let me give away copies, but I was able to buy it. So when you go to Amazon, the link is in the chat. You can just do !book or click the link up at the top. You're this book. So if you've read it, I would really appreciate it if you give a review. God bless you. Thank you for your support. If you haven't read it yet, feel free to pick it up. All right. It is #1 in new release in the category of like leadership, political leadership. It's floating between 40,000 and 42,000. It jumped 15,000 spots overnight on the overall bestseller list. Got as high as like 40,000, and it tends to like go up, down, and then up again. So you can really help this book because it thinks that a lot of people buying a small like publisher's new book means it's like a really like good and important material. So God bless you. And you can see it's actually number 8 in the campaigns and election subcategory. So there's elections and political process. It's like number 26, 25. But in the campaigns category, I am next to like, I'm ahead of Tom Hartman and Dana Bash and some of these folks, and I'm right next to Nate Silver, Saul Alinsky, Hillary Clinton, and Maggie Haberman. So you've all done a great thing. I know a lot of you were saying thank you to me for my coverage. Thank you for watching that hearing. I will be live tomorrow from in court in Norfolk Superior Court for the big Proctorgate hearing. But until then, if you'd like to support and you want to pick up Tal's book, let's see if we can get this thing up the charts. You know what I'm saying? So, yes, feel free. Now, let me just show you how it works. So when you go to this feed, you're going to click Read Now, okay? You don't need a Kindle. Someone asked me earlier. Thank you. That was a great question. you don't need a Kindle. When you buy it, it's going to open up a link for you, even if you don't have a Kindle, on your desktop or however it works. And it's just going to open the book. All right? So you can see here there's a chapter list. Okay, you can click that on the right. Now, when you use this chapter list, it works. I did this by hand. Every chapter, okay, you can just go through the book. Okay, all the sources are clickable. Okay, it's a really cool book. Okay, you can just go to any source linked in the book, read all the primary documents yourself, read all the federal documents, can learn all about the different cases. I think it's really important. So God bless you all and thank you for your support. That's how easy it is to pick up your copy of Boss Tweed Days in Norfolk County, The Rise and Fall of Michael Morrissey's Machine. Speaking of Norfolk County, we have the motion on Aidan Carney's, the ruling on Aidan Carney's motion to dismiss from Judge Belzios. Now, I can already tell him to get all mad. All right? I know this is going to make me mad, so I put the voice of our very evil man. All right? And we have our very special reporter towel. He's evil and he's mad. All right, take it away. Okay? Would you like to begin? Hold on one second. It did begin. I just have to turn the volume up. I code these. I make these by hand. All right, so they're Towel original productions. All right, so here we go. The ruling on the Aidan Carney motion to dismiss in the context of his criminal charges related to the Karen Reed and John O'Keefe case. This almost guarantees an evidentiary hearing with Kate Pita and Brian Tully and who knows. You think Rosemary Scapicchio is going to tee off tomorrow? Wait till you see Mark Betterow with some of those folks on the stand. Here we go.
D7, Commonwealth of Massachusetts, Norfolk, SS, Superior Court, 2382 CR 00313 2582.
By the way, so Aidan Carney is facing criminal charges by the same state police unit that was involved in the Birchmore cover-up, the same state police unit that was involved in the John O'Keefe cover-up, the same state police unit that was involved in the Tiffany Overstreet cover-up, Brian Tully and John effing Fanning. Okay, Aidan Carney was charged for, in essence, having a rally outside. Oh, God bless you, T-A-U-A. What a wonderful name, Tawa. Thank you for your support. He was charged originally because he had a rolling rally. He had a protest outside, like he went through the town of Canton having a protest about the cover-up of John's death. Okay. There were 16 charges. 6 of those got dismissed. Then there were 3 more charges. Okay, so it went up at one point to like 19. Then 3 of those got dismissed. Okay, so then it went from 19 to 10. Then 2 more charges got added because of the window shop incident, the infamous, I'm a window shopper. I have to stop watching Jolene. It's hilarious, but I can't be singing when I'm talking about criminal cases, okay? She's freaking hilarious, but I watch 15 seconds before I go to bed, and I'm singing Window Shopper by 50 Cent the next day while talking about the window shop incident. Anyway, my point is, so then, as one is wont to do, Aidan yells at a window shop of a pizza shop, all right? And the pizza shop was not even open, okay? And then the next day, he faces more charges, but they don't revoke his bail. So the total number of charges remaining is 12. And this is a motion to dismiss those 12 charges. Everybody understand? I get so frustrated when I see people trying to talk about these cases and they don't know what they're talking about. And I'm like, you don't know what charges are left. You don't know who the witnesses are. You don't. And then, by the way, let me just explain this to you. This is the strangest criminal case of all time. Let me make a post about this so I can tell people we're going to cover this. This is the strangest criminal case of all time. You want to know why? Because you're going to find out that the PI that Brian Tully's state police unit worked with to try to get Aidan Carney was Kate Peter, this woman who used to work with Aidan until they had a falling out over, it's either, whether I tend to believe Aidan about this, whether you believe Aidan's story, which is that Kate took money from him and then embezzled it and then ran, or Kate's story is that she wanted to go out on her own and Aidan was jealous and wouldn't let her. Okay, Proctorgate hearing done. Now I will review the ruling on the Dr. Turtleboy motion to dismiss and probably yell about things. All right, so Kate Peter, okay, is a PI. She's working for this guy named Marty Kraft. Marty Kraft used to know John O'Keefe. Marty Kraft was a Boston police officer. Kate Peter starts putting all these weird people in Aidan Carney's orbit. They're all her friends, but they're pretending to be turtle riders, and she's been doing this for years. Dude, she's like Helga from Hey Arnold. Now, you might be saying, Grant, why do you even know about this stuff? Because it's operative to the criminal case, because Michael Morrissey and Brian Tully had this woman who was running a Discord server that Morrissey was sending himself links to, where the witnesses in Turtle Boy's case and Karen's case, who are very politically connected to the Morrissey machine, were talking to each other. All right? And so it's not really this Kate Peter woman. What makes this case strange is it was almost like the state police and the Norfolk DA were like acting like attack dogs for private interest, and then this woman who has this like I call it a crush. She's like Helga from Hey Arnold. Okay, you may as well imagine her as someone who's built a shrine out of gum to Aidan Carney, but you can't have him because she's not his type. That's the best way I can describe her as a reporter, in my opinion. Okay, so because she can't have Aidan, what she does is she tries to bring him down. But you can't bring Turtle Boy down, because he's Turtle Boy. He's just going to keep being Turtle Boy, and no one's going to stop him. It would be like saying you're going to bring Dave Portnoy down. Like, what? First of all, what are you, some type of, jihadi? Second of all, you're not going to do that. So what Kate does is she tries to mentally torment him by proxy by putting people in his life. So, she'll find people who will just be around him and pretend to be turtle riders. A good example is the guy who line sat for Aidan during the Karen Reed trial. That dude has been a Kate Peter rider since the beginning. I don't even think Kate Peter has riders. I think she has pressured informants who the state police know committed crimes, so they have Kate go to them and be like, you're going to do what we want or we're going to arrest you. All right, that's my opinion. And they just kind of targeted this weaponized political machine in the form of an abusive prosecution at Aidan Carney. Now, you might be like, well, Grant, the check and balance is the judges. Yeah, no, not in Norfolk County, okay? Now, I'm going to read what Judge Balzaios has to say, but just realize, there is an active federal probe of this entire state, in particular related to this type of misconduct. Aidan Carney threw himself on the fire in a lot of ways. People don't like him and his style, but seriously, his style is not that brash compared to Howard Stern. Okay, what he's really doing is creating cases for the feds. Rachel Rollins, Monica Cannon Grant. He should create a case on Rachel Rollins. I think she's a rat. All right, look, commie. That's my opinion. You want to block me on Twitter, do you, Miss Rollins? We'll see about that. I might have to call the DOJ OIG. I should call Maine Justice, in fact. I should be like, the Biden DOJ declined to prosecute Rachel Rollins, but screw it. That doesn't give her double jeopardy protection. I know Bluford v. Arkansas. I'll start yelling. Miss Rollins, you want to block me on Twitter? Make me all mad. My point is, so Turtle Boy is very good at writing stories that build federal corruption cases, especially about police that abuse vulnerable women. And he throws himself on the fire. He's like, screw it. And so he took a lot of shit. I don't think he expected Kate Peter to get involved, because frankly, I don't think anyone saw that coming. Riccio was involved before Kate Peter. You know what I'm saying? So that was the wild part here. Now, why is this all relevant? Well, because part of the outstanding arguments, the remaining arguments before this thing goes to trial, if it goes to trial in November, I don't think it's going to go to trial if Deitch wins next week. Adam Deitch. If Adam Deitch wins the September 1st primary, I don't see this case going to trial. I'm saying it could, but it would be like asking for those people to be criminally charged as soon as Deitch takes office for something. But my point remains the same. This the outstanding evidentiary disputes are like, what was the role of Kate Peter in this process? What did Michael Morrissey say to Kate Peter about her role collecting evidence? Like, how much evidence that Michael Morrissey got was actually laundered, like illegally obtained, and then reconstructed through Tully and his unit and Yuri and all them? How much information was withheld in violation of Rule 14 from Aiden that's exculpatory or otherwise? How much of the Proctorgate material did Aiden not get access to, and how prejudicial is that to his ability to effectively argue his defense? Was the grand jury proceeding compromised? And remember, Ken Mello, the initial special prosecutor on this case, has since died. Okay? So just remember all that. Like, what you think, when you go at Turtle Boy, whether you love or hate him, when you go at him, what you're doing is carrying water for Kate Peter, Brian Tully, John Fanning, and Michael Morrissey. Okay? That's why I want to check and balance this shit. I'm sick of it. I'm sick of it. Why is Nick Rocco carrying water for Michael Morrissey, Kate Peter, John Fanning, and Brian Tully? Seriously. Because that's what I'm going to think of you if you go at Turtle Boy right now. It's a bad time to pick the losing side. Alright? The die is cast, so to speak. So, what the hell are these people doing? That's what I want to know. But that's a matter for another day, alright? Because now we're looking at Judge Belzeos' ruling on Aiden's renewed motion to dismiss. Now, you can see the oral arguments with Mr. Betterow and Mr. Bradel against Special Prosecutor Robert Cosgrove on this motion to dismiss. I was in court broadcasting it live. So, let me just say one thing about Ken Mello. And listen, I don't think even people, like, very close to this really know what happened. So I just want everyone to understand. Here's what happened. Ken Mello came onto the case in the fall of 2023, okay? Kate Peter was like coordinating a lot of this shit. She was like driving evidence to Nelson, Mello's investigator. Like, Kate was like running the grand jury. Tully was just doing like what Kate was just feeding Tully shit. Biff would like index the videos on her Discord, and then she would analyze them and pick shit out and make arguments and then frame it and write it and all this shit, deliver it into like a USB drive in a parking lot, and then the PI Nelson would take it to Ken, and Ken would bring it into court. Okay, that's what they were doing. Just so everyone understands, like, what's going on. And it gets worse, because in April of 2024, Ken Mello got very sick. He had cancer. He is dead now. Okay, may God rest his soul. And as a journalist, I would not say this if he were alive. It's not. You want to talk about journalistic privilege, then we're going to talk about it. And I would not say any of this if he were alive. All right? So, in April of 2024, Ken Mello was hospitalized. He was legitimately in the hospital. And Brian Tully, in his infinite wisdom, after doing a lot of favors for like Higgins and McCabe and all them to protect their phones, letting Natalie like delete a bunch of shit from her phone through a professional company before she turned it over, Tully takes Lindsay Gattani's phone and turns it over unredacted to Tim Bradel, except for messages from Tully to Lindsay and from Kate to Lindsay that were removed from the extraction. Okay? Hello, Nick Garino, the man of the hour, the cooperating federal witness, the man who dropped that fucking phone off after it was extracted. Didn't you, Mr. Garino? So anyway, we're so close. We're going to get these bastards. I'm telling you. So, Brian Tully in his infinite wisdom does this. Ken Mello did not know about that. That was done without Ken Mello's knowledge, consent, or permission. How do I know? Because Ken Mello was bawling his eyes out on the phone from his hospital bed where he was dying of cancer. He didn't know how long he had to live when he got the initial diagnosis. And he was in the hospital getting chemo. He was crying. And now you know why I missed my crim law final in 2024 and had to retake the class in the fall of 2025. all right? Because I wasn't going to leave her alone. There was court the next day. So, when that was done, that Ken Mello was taken off the case. He remained on the case in name only. They took him off the case because he went against the grain and reached out to Bradle and was like, hey, Bradle, like, screw Tully, I'm clawing that back. And that went against Morrissey's edict, and they took Ken off that case, and he was pissed. He was pissed that they undermined him. He was pissed that they took advantage of him. He was pissed that they would ever do that. He was pissed at how they treated Lindsay. He was pissed. He was just mad and sad and angry. I don't know what to say. There was nothing fake about it. He was legitimately mad and sad. He was crying. So, I know people don't love Ken Mello because of how it all went down in the beginning. I don't really know what happened. I never asked. I imagine he was a little brainwashed, like me. But when shit hit the fan, and he had a choice to either go along with it or get pissed, the second he saw something he didn't like, he was like, fuck it. Like, fuck, I'm out. Seriously. So, you know, I don't know. Maybe it was his faith. I never asked him. Like, maybe it was his faith. Maybe it was just he was so shocked they took it that far. But there was something about that day, April 23rd, 2024, Ken Mello changed forever. He was never the same after that day. I'm telling you. That really changed him as a person. I saw it in him. I heard it in his voice. I only just hope that he talked to the feds. I don't know if he did, and I wouldn't want to know. But listen, Garino's the one who can really make it the case. But Ken Mello was a fact witness to a substantial amount of misconduct, and he was not loyal to them. So I don't know what to say. God rest his soul. I don't know what he did before I met him. I don't. I never met him in person. But I don't know what... Well, I guess I was in the presence of him. I don't know what he did before that. But I know that when the chips were down and there was a really bad situation, it wasn't Ken Mello who did wrong. In fact, he tried to right the wrong. It was Brian Tully. It was Brian Tully that committed egregious misconduct, that enabled Kate Peter, that enabled this weird PI operation that got around Aiden and Karen. That was Tully. Okay? The buck stops with Morrissey and Tully, the detective lieutenant and the DA, and that is how the inquiry will begin from the congressional perspective. And we will ask questions until we find out who brought who on, who financed it, who paid for what, how did the money get distributed. You can get money in cash, bro. I'll find the bank you went to, I'll find the teller, I'll find the receipt, and then I'll look at the security camera footage. I will find who gave you that money. I'll trace every dollar, and we will find out who did this. But that's a question for another day. The operative question related to this motion to dismiss is it argues that it argues under Odell, DiBenedetto, or McCarthy, or some combination, or a combination of those three, that the grand jury proceeding was compromised because of Michael Proctor, because of Tully, because of Mello, because of Kate Peter, because of Morrissey, who's supposed to be recused from this. And that's why I'm telling you, I'm going to get mad, because you can't rule on this case about those issues when you have me around who saw all of this, and I'm going to be like, no, we're going to, I don't know what this ruling says. I haven't read it yet. It's 25 minutes. We'll listen to it. And I have to go to bed early, too, because I got to get up very early to get to Norfolk Superior Court for the 9 a.m. Proctorgate hearing with Rosemary, with Adam Lally and Lynn Beatty and Tully. God knows who else. I'm going to ask Tully if he wants to go to Amelia's for dinner after the hearing. I think he's going to turn me down. I'm going to tell him, I'm not into that anyway. Then I'm going to say, but I actually, unlike with Yuri, I don't have a good line for Tully. I think I'm just going to condemn him to hell. I really don't like him. He did bad things. He's a bad man. So anyway, my point is, stop trying to divide Aiden and Karen. They're both fighting similar evils. And whether you like Aiden's style or not, he's willing to take bullets. Just because I take bullets in a more like, I don't know, whatever you want to call this style, that doesn't make him or I any better or worse than each other. He just has a different way of taking the hits. And he's very good at it. He's very good at it. So I don't understand why people try to tear them apart. Just think of his work as kayfabe. The real work is the police corruption. The kayfabe, like taking the slings and arrows of outrageous fortune, is the drama. If you just like take all the hits and make yourself like a ridiculous target of attacks, then the bad men are overwhelmed and they can't focus when you backdoor them and investigate them for misconduct. All right, let's begin.
CR 00088, Commonwealth of Massachusetts, Yancy Aiden Timothy Kearney. Memorandum of Decision and Order on Defendant's Second Motion to Dismiss, Paper Number 103. The defendant, Aiden Timothy Kearney, has been indicted on several counts of witness intimidation and unlawful picketing. Presently before the court is Kearney's second motion to dismiss. The court conducted a non-evidentiary hearing on the motion on July 20th, 2026. After careful consideration, Kearney's motion to dismiss is danked. Discussion. 1. Impairment of the grand jury proceedings. The integrity of the grand jury proceedings has been impaired, and dismissal is warranted where the presentation of false or misleading evidence was presented with the knowledge that it was false, with the express purpose of obtaining an indictment, and probably influenced the grand jury's determination to hand up an indictment. Commonwealth v. Reyes, 98 Massachusetts Appellate Court, 797, 805, 2020, quoting Commonwealth v. Fernandez, 483 Massachusetts 1, 8, 2019. The defendant bears a heavy burden to show impairment of the grand jury proceeding. Commonwealth v. Lavelle, 414 Massachusetts 146, 150, 1993. The court fully adopts the summary of the evidence presented to the grand jury as outlined in this court's Doolin J. Memorandum of Decision and Order on Defendant's Motion to Dismiss, Paper Number 86. A. Waiver. The Commonwealth contends that Kearney waived several of his arguments now before the court because he failed to raise them in his first motion to dismiss. Kearney counters that even if he should have raised his arguments in his first motion, the court should exercise its discretion to hear and consider them. The court agrees that such arguments should have been presented in Kearney's first motion to dismiss under McCarthy and Odell, and Kearney has presented no compelling reason for the court to exercise its discretion to consider same. Pre-trial motions, such as the one presently before the court, are governed by Massachusetts Rule of Criminal Procedure 13A-2, which provides that any ground not stated which reasonably could have been known at the time, the pretrial motion is filed shall be deemed to have been waived, absent cause for relief from such waiver. See Commonwealth v. De Los Santos, 492, Massachusetts, 242, 249, 2023. The purpose of Massachusetts Rule Criminal Procedure 13A-2 is to alert both the judge and the Commonwealth to the theories at issue, id at 248, and ensure a timely disposition of the indictments lodged against the defendant. In a comprehensive memorandum of decision and order, dated May 19, 2025, this court, Doolin J., allowed in part and denied in part Kearney's first motion to dismiss the indictments against him. In his first motion, Kearney, relying on the testimony and evidence presented to the grand jury, argued in part that the indictments against him should be dismissed because the Commonwealth failed to establish probable cause to support the indictments, and that the integrity of the grand jury proceedings was impaired. See docket number 68. Now, Kearney brings forth a second motion to dismiss, in which he, again, contends that the integrity of the grand jury proceedings was impaired. In the motion presently before the court, Kearney argues he is entitled to dismissal because the prosecutor, 1. presented false and misleading testimony, 2. introduced evidence of uncharged bad acts, 3. failed to provide the grand jury with limiting instructions regarding such uncharged bad acts, 4. edited Kearney's episodes and failed to admit the full versions of said episodes, 5. renamed the titles of Kearney's episodes from which the video exhibits were taken, and 6. placed the video exhibits in a folder labeled Intent. See docket number 104, pages 3 to 15, docket number 103. All of Kearney's aforementioned contentions now before the court were, or reasonably could have been, known to him when he filed his first motion, to dismiss, as both motions are based solely upon the evidence and testimony presented to the grand jury. Kearney has failed to show cause for relief from such waiver. See Massachusetts Rule of Criminal Procedure 13A 2. Nor has he made a showing that substantial justice requires the court permit him to renew his prior motion. See Massachusetts Rule of Criminal Procedure 13A 5. As such, the above arguments are deemed to have been waived. 2AC, the hearing of July 20th, 2026. Defense counsel focused his argument on sections 5. Introducing prior bad acts, and 3. Failure to provide limiting instructions to the grand jury. While the court has already determined that such arguments have been waived and / or previously decided in paper number 86, it is worth noting that neither argument supports dismissal. Even if the court accepts the proposition that the Commonwealth improperly exposed the grand jury to evidence of uncharged crimes as argued in 2. Such exposure is dwarfed by quantum of improper evidence which the Supreme Judicial Court deemed insufficient to warrant dismissal in Commonwealth v. Brown, 490 Massachusetts, 171, 2022. As to 3. The failure to provide the grand jury with limiting instructions, the defendant must establish that such instructions likely would have given effect to a complete defense, resulting in a no bill. See Fernandez, 438 Massachusetts at 8. In light of the comprehensive findings regarding probable cause set forth in paper number 86, this court concludes that even the most defense-friendly limiting instructions relative to the uncharged crimes would not have resulted in a no bill regarding the remaining indictments. 3. Here again, the court takes a moment to discuss an otherwise waived argument. Kearney contends the Commonwealth presented false or misleading evidence to the grand jury when it presented edited video excerpts from Kearney's online episodes. Kearney, however, fails to put forth evidence to show how such excerpts were edited, and what portion of the excerpts contained false or misleading information. Indeed, although Kearney contends Detective Lieutenant Brian Tully, Detective Lieutenant Tully, sliced and diced and edited the video exhibits presented to the grand jury, he concedes that Detective Lieutenant Tully accurately cited names of specific episodes, exact timestamps, and exact quotes within them in the charging documents. Deet, Lieutenant Tully submitted. Docket number 104, pages 5-9. Docket number 103, paragraphs 204 to 205. A comparison of the transcribed video exhibits provided in this court's Doolin, J. decision on Kearney's first motion to dismiss to the accurate quotes in the charging documents cuts against Kearney's contention that the Commonwealth presented false evidence to the grand jury. For Kearney also argues that the prosecutor failed to inform the grand jury that a third party sent the Commonwealth certain material. The court discusses this in Section JB, Infra.
The court's gonna talk about Kate Peter? Oh, this is the greatest day of my life. I know Aiden has lost this motion, but I still retain hope, that justice will prevail. Are you telling me this judge is gonna talk about Kate Peter? All right. I was born for this day.
Because they reasonably could have been known when he filed his first motion, T6 dismiss. C. De Los Santos, 492 Mass, at 249. Commonwealth versus Parker, 412 Mass, 353, 395 to 356, 1992. In any event, even if Kearney's arguments were not waived, Keamey's motion and supporting affidavits failed to satisfy the heavy burden of showing. Any of the aforementioned issues probably made a difference in the grand jury's decision to indict him. This is particularly true where, as here, the indictments are supported by probable cause. See docket number 86. Or B. Third-party involvement. One argument not raised in Kearney's first motion, because it reasonably could not have, C. been known to him when he filed it, is that the Commonwealth misled the grand jury by concealing the fact that a third party, KP, sent it certain material during the Commonwealth's investigation and in the weeks leading up to the start of the grand jury proceedings. To warrant dismissal, Kearney bears the heavy burden of showing that the Commonwealth's failure to inform the grand jury that KP sent material to the Commonwealth probably influenced the grand jury's decision to indict him. Secretary Fernandez, 483 Massachusetts at 8. Reyes, 98 Massachusetts Appeals Court at 805. Although KP undoubtedly sent the Commonwealth materials she believed evidenced Keamey's criminal conduct, there is nothing in the record to suggest that the Commonwealth's failure to inform the grand jury that she, one of many sources of information utilized by the investigators, influenced the grand jury's decision to indict him. Civilians, such as KP, routinely provide what they believe to be evidence of criminal conduct to the police. Notably, Detective Lieutenant Tully has asserted that in
Stop! Time out! No! No! Oh no! She was working as a PI. No! This is ripe for appeal. She is not a civilian. Oh God! Oh yeah! Oh, he's got her. Oh yeah! Mr. Betterow, swing for the fences. Oh, Judge, you don't know what you've done. Oh, she's not a civilian. That's it. Ahmed. Oh, wow. The judge who just denied the Dr. Turtleboy motion to dismiss classified private investigator Kate Peter, who spoke directly to Norfolk DA Michael Morrissey and Brian Tully as a civilian. Peter was working for PI Marty Kraft at the time, and I can prove it. Whoa. Oh, and that's one of the primary reasons Judge ruled that although Tully and the Norfolk DA's office did not disclose to the grand jurors in Kearney's cases that Peter was a source of information, Judge went on to say that this was immaterial because Peter was merely a civilian. This is foundationally, as a matter of fact, wrong. I need to look at the next part. No, it would have weighed the decision. Judge then goes on to say that even if Tully and the Norfolk DA's office had informed the grand jury that Kate was a source of information, that would not have impacted the decision to indict. However, Judge did not consider at all what it would mean if Tully and the Norfolk DA hid from the grand jurors that Peter was a PI who was actively working with Tully and the Norfolk DA's office to investigate and prosecute Kearney, which obviously under U.S. v. Heibel is an entirely different question than a mere civilian sending information to a police officer. Boom, bang, I win. Do not pass go. Do not collect $100. There's always, that is a foundational flaw. It's a factual, oh, Mr. Betterow, sir, we need an evidentiary hearing with Kate Peter immediately. We need a motion for reconsideration. This is wrong. Oh, it's wrong. Oh, Mr. Betterow. So, Mark, is it Mark Betterow or Mark? I think it's a. Is it Betterow Law? I forget what his Twitter handle is. Betterow Law. He finally unblocked me. God bless him. So, Betterow Law, about that evidentiary hearing with Kate Peter and Brian Tully that you wanted. Oh my word, she tanked the case. Judge doesn't even know. Oh, that's it! That's it! I'm mad. I'm all mad. You made me all mad. That's what happens when you make me mad. Now listen, on the whole, you know, Judge was doing good there. I hated the ruling, but he was being sneaky. He was being all sneaky, and I couldn't get around it. I just couldn't, because that standard of you could have known about this in your first motion to dismiss on the video titles was too much. But nope. Judge out sneakied himself. He worked himself into a shoot. I got him. He's wrong, and the analysis is wrong as a result. I'm not a lawyer. This is not legal advice, but I did go to law school. He's wrong. He's just wrong. No, and you can't even do the analysis of whether or not there would be sufficient probable cause in light of an incorrect analysis of what Kate Peters' role was in the process, because how do you know what the grand jury, how can you even analyze the resultant probable cause if you don't analyze correctly Kate Peters' role in it all? Oh, this is outrageous. It's a travesty. It's a sham. It's a mockery. I demand redress of my grievances from my government. I'm all mad. Listen, if you haven't watched this stream before, sometimes I get all mad. It's an incorrect finding of fact, indeed, to our girlfriend. It's almost like a premise. It's almost like assuming the premise, and the premise is wrong. I tell you, the premise is wrong. I do declare. All right, can I please have a link to this document, please, while you be in Illinois? The premise is simply wrong. I object. I object. I object on every conceivable ground. T.A. Sarah, this is when you just stand up and you start yelling, I object. When the judge says, why are you objecting? Hopefully you have a good answer. This is outrageous. I mean, listen. I just can't believe that this is so wrong. There's evidence of her being a PI. This isn't even really in dispute. That means you got to call Kraft too. Listen, we really got to get to the bottom of what went down with this chaos. Could I please share my document? You're being very annoying. All right, thank you. All right, so it's going to be, what page was this? It's going to be SOAR page 4 into 5. All right. All right, let's get down to work. Come on now. All right. Source page 4 into 5 here. All right. Now, I'm going to go get my highball write-up. You know, I got something special in store for Miss PETA. I'm going to go get my highball write-up. Now, I normally wouldn't do this, you know. I normally would just write it up, kind of go about my business. But no, for this one, no. She gets the highball treatment. Now, highball, if you don't know about highball, let me just tell you, folks. Highball is a fascinating case. You see, there was this woman, and legitimately, she had concerns that her partner was abusing her daughter. So she called the police. And the police show up at the scene, all right? And they're like, ma'am, we would like to help you. Where is this man? And she's like, well, he left. And the police say to her, well, can you find him? And she's like, well, he left his phone in the car. And the cop says to her, can you, oh, do you have the phone? He does not instruct her to get the phone. Remember that. He just says, do you have it? All right. She goes over to the phone. She brings it back to him, and she's like, listen, this is his phone. There's pictures on this phone of him doing terrible freaking things to my daughter. And the cop's like, okay. And he takes the phone, and it's just open, right? She hands it to him. It's just open. And it's not locked. All right. So he starts looking through it, and there's no evidence of her allegations. So he's like, okay, listen, I believe you, but I don't know how this phone structure works. So I'm going to take the phone, and I'm going to bring it back to the station. We're going to forensically analyze it. So he does that, and the cop finds the evidence that the mother said was there. So he gets a criminal warrant, and he arrests the guy. All right. Now, you might be saying to yourself, well, what's the relevance of that? All right. Well, let me play you this clip from when I'm on Attorney Melanie Little's show. Pass towel in a suit can explain it.
Never I would furnish information to police. I'm giving you this information, but the onus is on you to go out and investigate it, right? And they never asked me for anything. I was just giving it. So there's not there's any sort of coordination or any sort of indication of... What do you think?
Hold on. Okay, so yeah, this is big. So she has clearly been watching my streams, and I understand.
She's a whole team watching them. She's a whole team doing this for her.
Well, and I learn about highball, but so I have a hypothetical question for you. I also sent you a link in the private chat to exactly what you just described, bumping. Described by a former CIA and FBI guy. You're going to find it fascinating. But let me say this about highball. So what's really interesting about what Kate Peter just said is, let me give you a hypothetical. Under the exclusionary rule and Rule 14, would it be permissible, hypothetically, for a private intelligence informant working under a private intel firm with plausible deniability, who said they were never directly told to do this by a state police officer or a member of the Norfolk DA's office, to, I don't know, let's say pretend to get romantically involved with someone, get really close to them, get a vulnerable time, and then after getting close to them, do a bunch of things, and also steal their computer, make a complete copy of it, and then try to civil and criminal proceedings. Because Hybel has a 3-factor test. So Hybel, of course, is from the Eighth Circuit, and it has to do with the government agency doctrine. And what's so interesting about what case...
Oh, damn, you just broke up. Wait, hold on. Wait until you come back. Oh, no. Did we lose you? Okay, wait.
No,
okay.
I'm back.
Okay.
If you look at Hybel, the 3 factors for when someone becomes a government agent are, did the government instructor acquiesce to the civilian's conduct? Did the civilian have a primarily law enforcement purpose? And then the third prong of the Hybel test, I think, is... I'll have to look it up, but the Hybel case is an exact corollary here. In Hybel, there was a woman who called the police because her daughter was essayed by the man she was dating. The police come to her and arrive at the scene. The man's gone, but he had left his phone in her car. The police officer says to the woman, do you have the phone? And she says, yes. And this is a phone where he had taken pictures of the abuse of the child. So she goes to the car, gets the phone, brings it over to the officer. He does an initial cursory review, can't find it. They take it back to the station, they do forensic analysis and find it. They charge him. Should it be excluded? Was she acting as an agent of the government? The court said yes to one factor, whether the law enforcement officer acquiesced to her conduct. No to the primary law enforcement purpose. Her primary purpose there was protecting her kid. Yes, no to acting under an instruction from the officer. Why? Because the officer didn't say, go get the phone for me. Do you have the phone? So that's what she's thinking about. She's like, oh, I know Hybel says I got to go up. Oh, better, we're going to tear her apart. Good luck. Good luck. So you see what I mean? Now I have the Hybel post here, okay? I'm going to let you learn about Hybel, and then we're going to go back to the motion, but it becomes operative. I've been banging this drum for so long, telling people, please listen to me about the government agency doctrine. It changes the nature of the analysis because of how Hybel functions. And the reason I've been saying that is because of this. Because a civilian just sending police stuff, okay, is not the same as a government actor doing so. All right, so we're going to learn about the Hybel doctrine, but first I have to get 2 more pictures in order to fully complete my post that I'm going to make about this. First, I need to get the picture where Kate, there it is, confirms to be working Marty Kraft, and then also Kate talks about talking to my mother back in like March of 2024, and I'm like, bruh, is that why Michael Proctor's uncle-in-law, who's still a statey, and who's Liz Proctor's uncle, ended up in my mom's life? That makes me all mad. That's familial alienation. I'll tell you what right now, I get all mad. So then it made me wonder, like, who's coordinating this? You know, who's paying for what and why? And then I started digging. Not to mention, like, all of this. The judge just didn't, not just didn't get it. Really, like, there's a direct connection to Kate's Discord server. It's with Morrissey's emails. That's going to make that Morrissey Discord FOIA really big deal. Peter, a disaffected former colleague of Kearney who developed a Helga Pataki-like obsession with him when she couldn't make Kearney her own. Frankly, bro, listen, everybody has their own tastes, okay? Aiden just is not that into you, all right? He's just not that into you, all right? Everybody's born with unique genetics, okay? You should be proud of them, but that doesn't mean you're the right person for everyone, all right? That's just a general life lesson. And how do you spell Helga Pataki? Is it Pataki? I want to make sure I get this one right. Helga Pataki. Yeah, Pataki. There you go. All right. And then what else? Peter also ran a secret Discord server connected to witnesses in Aiden's case and the Karen Reed case, which Michael Morrissey then linked to directly in his emails. A FOIA for more information about Morrissey's links to that Discord is forthcoming. All right, now that's how you write it up. I found a structural, factual, denial motion to dismiss. All right, a structure, and then I'm writing up this long article so I can get, when I get made, I like to write stuff up to express myself. Being all made, it's all made, so there you go. And when I get all made, well, you know, then I gotta go get the sources, I gotta collect the evidence, I gotta find my Hybel analysis, I gotta get the primary sources, and I gotta construct a logical argument with evidence for why I am made. Then get on made. I'll also take a bow. That was a good one. I'm always looking for stuff like that when I read decisions. You can make a decision I don't like that's legally sound, and I'm not going to get made. But if it's factually invalid and hence legally unsound, I'm going to get all made. And now I'm all made. All right, who's ready to learn about Hybel? I'm so excited. Oh, I got excited when I got to talk to Attorney Melanie Little about Hybel. I love the doctrine from Hybel. You don't understand. Maybe you do understand. All right, here we go. Who's for the Hybel post? It's really good. Okay, British reporter Tal, you have an important job. Take it away. I have faith in you. Yes, British reporter Tal. Any minute now. Go ahead.
Conversation. Good morning. I think some people may not fully understand the implications of the government agency doctrine in the context of the relationship between Kate Peter, Brian Tully and Yuri Buchanek regarding the Karen Reed and Turtle Boy investigations. Here's an overview, via Grok, trained on my transcript about the US versus Hybel case. Overview and application of the Hybel test and Rule 14 to Kate Peter's involvement in the Karen Reed and Aidan Kearney cases. In United States versus Hybel, 900 F3D 975, 8th CIR. 2018, the 8th Circuit Court of Appeals addressed whether a private citizen, a mother retrieving a cell phone from her boyfriend's car, acted as a government agent when providing evidence to police, triggering Fourth Amendment protections against unreasonable searches and seizures. The Fourth Amendment applies only to government actions or those by private parties acting as instruments or agents of the government, Skinner versus Railway Labor Executives AS in 489 U.S. 602, 614, 1989. If deemed an agent, the search requires a warrant or exception, otherwise, it does not. The court applied a totality of the circumstances test to determine agency, focusing on the government's participation in the private party's activities, United States versus West, 596 F3D 906, 910, 8th CIR. 2010. This involves three key factors. The defendant bears the burden of proof. 1. Government knowledge and acquiescence. Did the government know about and consent to, or fail to stop, the intrusive conduct? In Hybel, this factor favored agency because the officer was present, asked about the phone, and observed the citizen enter the vehicle without intervening. 2. Citizen's intent. Was the citizen motivated solely or primarily to assist law enforcement, or did they act mainly for personal purposes? Even if there is some intent to aid police, dual motives, e.g., personal protection, weigh against agency, United States versus Smith, 383 F3D 700, 705, 8th CIR. 2004. In Hybel, this weighed against agency. The citizen's primary motive was protecting her daughter and advancing a custody dispute, not just helping police. 3. Government request. Did the citizen act at the government's explicit or implicit request? In Hybel, this weighed against agency. The officer merely asked, "Do you have the phone?" An inquiry about possession, without directing a search, making the action voluntary and unsolicited. The court affirmed the denial of suppression, finding no agency overall despite the first factor, as the search was not government-directed and the citizen's motives were mixed. Extension to discovery obligations under Massachusetts Rule 14. If a private citizen is deemed a government agent under this test, their actions become attributable to the prosecution team, e.g., as an extension of law enforcement. Under Mass. R. Crim. P. 14, the prosecution must disclose all exculpatory evidence, statements, and materials in the possession, custody, or control of the prosecution team, which includes agents. This could expand discovery to include the agent's communications, records, or evidence, e.g., deleted messages or coordination with DA staff, potentially revealing conflicts, biases, or misconduct. Failure to disclose could lead to suppression, sanctions, or case dismissal, with serious implications in cases like those involving witnesses or informants coordinating with authorities. Application to Kate Peters' role and additional evidence. Based on the available details from public records, court filings, and related communications, including the September 29, 2023, email from Kate Peter to Massachusetts State Police Sergeant Yuri Bekenick, as referenced in recent analyses and motions. Kate Peters' actions as a private investigator, PI, working for Marty Kraft, allegedly hired by Jen McCabe to survey visitors to Karen Reed's home starting in February 2022. Raise significant questions about her status as a government agent under the Hybel framework. This includes Norfolk DA Michael Morrissey's email to himself with an attachment linking to Peters' Discord server, used by witnesses like Jen McCabe and Michael Proctor's wife. Peters' deletion of the server and her old phone amid Kearney's defense motions in late 2024, early 2025, her provision of Google Drive links to MSP Lieutenant Brian Tully for grand jury submission in Kearney's 2024 cases involving Lindsay Gaetani. Her subsequent deletion of those links, erasing the sole record of the evidence, and the Norfolk DA's noli prosequi, dismissal without prejudice, of those specific charges. These actions suggest coordinated efforts to manipulate and conceal evidence, expanding the prosecution's Rule 14 discovery obligations and raising serious due process violations. Peters' role reportedly involved gathering and sharing information on the John O'Keefe death investigation, in which Reed was charged, including direct emails to Bekenick, a key MSP investigator, and coordination with other law enforcement figures like Brian Tully. Her work for Kraft allegedly extended to surveillance tied to witnesses, e.g., McCabe, a central figure in the case, blurring private and state interests. The non-disclosure of key materials, such as the 2023 email and related report, information provided by Peter to Bekenick, further complicates the prosecution's duties, especially noting that David Unetti, Reed's attorney, recent ex-post highlighting this withheld information from September 2023, which was not provided during discovery in either of Reed's trials. Applying Hybel to specific examples of misconduct and violations. The totality of circumstances strongly supports Peters' classification as a government agent, as all factors indicate substantial government participation. This echoes Skinner and Smith precedents cited in Hybel, where private actions become state attributable if directed or heavily influenced by officials. If deemed an agent, her searches, surveillances, and communications are subject to Fourth Amendment scrutiny, potentially invalidating evidence she gathered without warrants. Below, each key example is analyzed through the Hybel factors, followed by Rule 14 implications. 1. Morrissey's email linking to Peters' Discord server. Hybel Factor 1, knowledge and acquiescence, overwhelmingly supports agency, as Morrissey's email, from his personal account to evade public records requests, directly linked to Peters' Discord, which served as a hub for witnesses, e.g., McCabe's, Albert's. Proctor's associates, coordinating on the Reed and Kearney cases. The DA's office acquiesced by relying on her inputs without verification. Hybel Factor 2, citizens' intent. Peters' motives were primarily to aid law enforcement, demonstrated by her use of the server to spread disinformation benefiting the state, unlike Hybel's mixed personal motives. Hybel Factor 3, government request. Implicit endorsement via Morrissey's personal involvement suggests directed collaboration, going beyond Hybel's neutral inquiry. Rule 14 implications. As an agent, the Discord contents fall under prosecution control, mandating disclosure of exculpatory material, e.g., witness biases. Non-disclosure hid attachments relevant to witness credibility in Reed's trials, potentially violating Brady obligations and warranting suppression or sanctions. The use of personal emails raises ethical concerns about evading FOIA, PRA requests. 2. Peter's deletion of the Discord server and old phone. Hybel Factor 1, Knowledge and Acquiescence, favors agency, as deletions occurred amid Kearney's 2024-2025 motions flagging Peter as a witness, without government intervention, implying tolerance. Hybel Factor 2, Citizens' Intent, strongly indicates primary intent to protect law enforcement, showing consciousness of guilt and alignment with insulating MSP, DA from scrutiny, e.g., in related probes like Sandra Birchmore's murder cover-up, contrasting Hybel's dual motives. Hybel Factor 3, Government Request. If deletions were to shield shared evidence, it suggests implicit state behest. Rule 14 Implications constitutes spoliation, requiring disclosure of any recoverable chats as prosecution team materials. Failure denied defenses, e.g., UNETI, material on conflicts, like Peter's ties to MSP, DA amid her own Norfolk charges, where she received favorable pleas, potentially leading to dismissals or civil liability for malicious prosecution. 3. Peter's provision and deletion of Google Drive links submitted by Tully to grand jury. Hybel Factor 1, Knowledge and Acquiescence, supports agency, as Tully used Peter's unvetted links in grand jury proceedings despite her biases, showing active acceptance. Hybel Factor 2, Citizens' Intent, Peter's deletions post-grand jury demonstrate intent to aid law enforcement by erasing records, not personal motives as in Hybel. Hybel Factor 3, Government Request, explicit via Tully soliciting and submitting the links, delegating tasks beyond Hybel's inquiry. Rule 14 Implications. Erased evidence must be disclosed as chain of custody material. Non-disclosure, mirroring Tully's editing of Gaetani's phone extraction, removing Peter, Tully messages, violates obligations, potentially triggering sanctions or disqualification motions, e.g. Bedero's allegations of Peter, Tully conspiracy. 4. Norfolk DA's nolli prosequi of Kearney's 2024 Gaetani-related charges. Hybel Factor 1, Knowledge and Acquiescence, indicates acquiescence to Peter's deletions by dismissing charges post-erasure, avoiding scrutiny. Hybel Factor 2, Citizens' Intent, aligns with Peter's law enforcement aid, as dismissal protects her role. Hybel Factor 3, Government Request, appears designed to moot discovery, implying coordinated direction. Rule 14 Implications suggests a cover-up to avoid disclosing erased evidence in ongoing cases, bolstering arguments for expanded discovery, e.g., Morrissey's records, Tully's DOJ NDA on MSP performance. This could violate due process, warranting judicial remedies like evidence suppression or retrials, and links to broader federal probes, e.g., Birchmore cover-up. 5. Peter's September 29, 2023, email to Yuri Buchanek and PI work for Marty Kraft. Hybel Factor 1, Knowledge and Acquiescence. This factor strongly favors finding agency. Public filings and emails show MSP and Norfolk DA personnel, including Buchanek, were aware of and accepted Peter's intrusive conduct, such as providing unvetted evidence or reports on Reed's case. For instance, the September 29, 2023, email from Peter to Buchanek contained details on the O'Keefe investigation, which Buchanek reportedly used or referenced without rejecting her involvement. Unlike Hybel, where the officer merely observed a brief search, here law enforcement actively received and potentially relied on Peter's inputs over months, acquiescing to her role in an ongoing probe. Peter's broader network, allegedly including Discord groups with McCabe's, Albert's, and Proctor's associates, further suggests tolerated integration into official efforts, especially if tied to McCabe's hiring of Kraft's firm to monitor Reed's home visitors. Hybel Factor 2, Citizens' Intent. This also leans toward agency, as Peter's primary motive appears to have been assisting law enforcement rather than purely personal purposes. Court documents from related cases, e.g., Aidan Kearney's motions, describe Peter as motivated by an obsessive hatred of critics like Kearney and Reed, but her actions, such as emailing Buchanek with investigative details and coordinating with Tully, John Fanning, and others, were explicitly to aid prosecutions. This differs from Hybel's dual motive scenario, personal child protection plus police aid, where the personal motive predominated. Peter's PI work for Kraft, while nominally private, reportedly bled over into militant tactics supporting police, e.g., insulating officers from Fourth Amendment violations. And her communications indicate intent to get targets locked up. If her Discord operations involved hunting predators but extended to manipulating evidence in Reed's case, this reinforces a law enforcement-aligned purpose, not a neutral or solely private one. Hybel Factor 3, Government Request. Evidence suggests implicit or explicit requests, tipping this factor toward agency. While Peter may have inserted herself, initially, per Kearney's defense letters, filings indicate she carried out tasks delegated by figures like Special Prosecutor Ken Mello and received favorable treatment in her own pending charges, e.g. witness intimidation cases in Norfolk County. The Kraft-McCabe connection, where McCabe, a prosecution witness, hired the firm to spy on Reed's associates, implies law enforcement encouragement or direction, especially given overlaps with MSP, e.g., Buchanan's supervision of Michael Proctor. Unlike Hybel's neutral inquiry, do you have the phone? Peter's ongoing provision of reports and advice, e.g., to Mello on Kearney's detention, points to solicited involvement, potentially via Tully or others. Rule 14 implications. As a potential government agent, Peter's materials fall within the possession, custody, or control of the prosecution team under Rule 14. 1. Requiring mandatory disclosure of exculpatory evidence, witness statements, and relevant documents. The Norfolk DA's failure to turn over the September 2023 email report to Yannetti during discovery for Reed's first or second trial, despite its relevance to witness credibility, biases, and alternative theories, constitutes a potential violation. This email, sent while Peter worked for Kraft, reportedly discussed O'Keefe, Reed details and was not provided, mirroring broader withholdings like Morrissey's self-email of Peter's Discord attachments, involving McCabe's, Albert's, and Proctor's wife, or the March 7, 2024. NDA between Tully and the DOJ on MSP investigations. Such non-disclosures could undermine Reed's defense by hiding conflicts, e.g., Peter's ties to prosecution witnesses via Discord, potentially used to delete evidence or coordinate. This ties into Brady obligations, embedded in Rule 14, where suppressing evidence favorable to the accused violates due process. If Peter's agency triggered expanded discovery, e.g., her full communications, surveillance notes, or Discord records, the DA's omission could lead to suppression motions, retrial dismissals, or sanctions, especially if it insulated MSP from liability for Fourth Amendment issues, e.g. improper evidence handling. Yannetti's repost of your post underscores this, highlighting the email's existence only after public revelation, not through official channels. 6. Robert Cosgrove's failure to disclose the February 2024 email between Kate Peter and Ken Mello. Hybel Factor 1, Knowledge and Acquiescence. Government acquiescence is evident, as Mello, and later Cosgrove, knew of Peter's input without rejection. Hybel Factor 2, Citizen's Intent. Her intent was clearly to assist law enforcement in Kearney's detention. Hybel Factor 3, Government Request. While not explicitly requested, the ongoing coordination, e.g., Peter's rewards, like withheld evidence in her own cases, implies solicitation. Rule 14 implications. Rule 14 requires timely disclosure of all relevant materials, especially exculpatory ones showing bias or improper influence. Cosgrove's omission, despite asserting thorough review, suggests selective withholding, potentially to shield Peter's role and avoid recusal motions, e.g., Norfolk DA conflicts in Peter's own felony cases, like the Lauren Murray incident. This could violate Brady, leading to motions for sanctions, dismissal, as in Kearney's case, where Bederow filed for disqualification and dismissal, citing Peter's unvetted evidence to grand juries. Cosgrove withdrew in September 2025 amid allegations of improper ex-parte contacts and non-disclosure. Broader collateral effects, links to Reed's case, e.g., shared witnesses like McCabe's, edited phone extractions like Gaetani's, could trigger mistrial or evidence suppression if Peter's agency exposes manipulated discovery, e.g., Tully editing messages involving Peter. Ethical and systemic issues. Cosgrove's failure, amid Peter's Discord deletions and MSP cover-ups, e.g., Sandra Birchmore, Farwell cooperation, risks eroding trust, prompting federal oversight, e.g., DOJ NDA. In Kearney's orbit, it fuels claims of corruption, potentially voiding indictments. Overall, These lapses highlight how Peter's embedded role amplified non-disclosure risks, potentially denying fair trials and warranting judicial remedies. If unresolved, they could cascade to related cases, emphasizing the need for independent review.
I would say so. So now do you see why, when the core of this is the sentence, civilians such as Kate Peter routinely provide what they believe to be evidence of criminal conduct to police, it's the wrong analysis. It's wrong as a matter of fact, and then it's wrong as a matter of law as a result. If the building block of your analysis is this is just withheld, Tully and Mello and the Norfolk DA withheld from the grand jurors that Kate Peter was just a civilian and passing along information, then it's not the same analysis. That's much simpler. That's not what we have here. That would be like, I don't know, some random person who just like sees a post on the internet and is like, I don't understand what Turtle Boy's doing, and I'm manipulated by the state police, and I'm propagandized, so I'm going to try to take him down and then I'm going to inadvertently end up protecting a child trafficking network in Norfolk County. That is what that would be like. But it's not the same as when you have a PI actively involved in two different but related investigations for the same state police unit. And that, ladies and gentlemen, is why the analysis is wrong. Because the grand jury might have thought about that evidence and the entire prosecution differently. Thus, the PC, the probable cause analysis, is different. Might be the same conclusion, I don't know. But you got to at least do, that's why it's wrong. Because you can't go from a false premise and then assert a conclusion. Because the premise is, first of all, factually wrong. And second of all, you didn't do the correct legal analysis. Just like Judge Gilday. You know what? You know what? Don't make me. I'll do it. I'll search the name. I will search his name right now. I'm going to do it. That's it. I sprat. That's it. What's this judge's name? Judge Belzeos. Oh, now you got me interested. That's bad. That's bad. You don't want to get Towel interested. Ask Kathy Rumler. She'll be like, no, I should have taken I took the Karen Reed approach. I didn't say anything. He still got made. Yeah, because unlike Karen Reed, some of you did bad things. You were bad. All right, give me a hit. What do you got for me? All right, let's go to the Secretary of State. What companies have you been involved with? Maybe none. Well, we should check your financial disclosures as well, shouldn't we? All right, I'm going. All right, let's see, Mr. Belzeos. What did you do with your life before you became a judge? Do anything interesting? Oh! Wait a minute. That kind of rings a bell. What did you do with this company that you owned, Judge Belzeos? You just opened a company? Interesting. And what are you going to be doing with this company? Real estate management. And you're working with a woman named Elizabeth Aprino. Who's that? Who is that? Let's find out, shall we, Your Honor? I mean, listen, it's not my fault. You opened the company. Who's Elizabeth Aprino? Let's find out. What do you do with your life, ma'am? What connection do... Why are you running a company with a judge? What? That's a little odd. Why are you... What? What? This can't be right. What? Why would Judge Belzeos be running a real estate company with a 29-year-old woman? This can't be right. He is Christopher P. Belzeos, right? Unless there's another Christopher P. Belzeos in Massachusetts. No, I can find out if it's him. What? What? It's a little odd, don't you think? It was just opened in May of 2026 as well. When did Judge Belzeos get specially assigned to this case? Oh, dear God. Do I even want to know? Honestly, do I even want to know? When was Judge Belzeos assigned to this case? What the hell is 460? What are you doing with this company? What are you managing? Let's find out here, shall we? Oh. Oh. You bought what? Is it an apartment? Oh, it's a home. Is he? What? What? But they have their own homes. Why did they have to buy this home? Well, now I have a lot of questions. What is going on here? I have a lot of questions. Yeah, why does Judge... Why... What is this? This makes absolutely no sense whatsoever. Let me see the financial disclosures. Okay, I want to, how do I look up judicial financial disclosures in Massachusetts? I know I've done this before. They're hard to find. I did it for Judge Krupp. That's how I tracked his companies. Judicial Nominating Commission, and then his name is Christopher P. Belzeos. Normally every judge has like this page dedicated to their nomination. And then people like track the disclosures. Nothing on him though. And in order to request his records, I can do it, but I have to do it through the ethics. There's like a portal. Governor Baker, huh? 2022? What did Judge Belzeos do before going to the bench? Let's see. Began his legal career in 1990, Brown Associates, criminal defense. Then he went to solo practice. Then he worked at Belzeos and Kratzner. Okay. Solo practice. Marshfield. Boy Scouts. Northeastern in 87. JD from Northeastern. So he was a little behind Gilday and the rest of them, but he was close. Alright, who is... Let's see, there's got to be something in here. Why does he have this company? This makes no sense. Who was Gratzner? There's only one Christopher B. Belzeos that I can find. So I'm not ruling out that this is just some other guy with the same... I can't rule that out. But let's just say, like, I'm pretty sure that's... There's only so many Christopher P. Belzeoses in Massachusetts. And, in fact, I can only find one. Mind you, there's only one that would fit that profile. That's very odd. That's very odd. I was expecting to find a lot of stuff, not that. That's a very strange thing to find. I mean, we got to start this paragraph over, by the way, because I got all made. But let me just tell you, that was odd. Yeah, I don't know. I can't. I'm sure some people will. You know, these are just public records. We'll track this down. It either is or it isn't him, but it's odd. The timing's odd. The person involved is everything about it's odd. That's all I'm going to say. Mind you, what caught my attention about this, and when my attention got caught to Judge Gilday, it was because he made a ridiculous, like, finding about the actual malice standard that just to say it offended my, like, it offended me. It offended the case law. Hello, mediocre mac and cheese. What a wonderful username. And it just was bad. All right. And so then I started, being a little towel, and I found Gilday on the corporate documents for Mikalakis, Marios Mikalakis, the owner of Amelia's and Stoughton and those other companies, the one who's going down on federal tax fraud. So, that's what kind of made me start looking around. I don't know. It could be a normal thing. It's just a little odd. Like, everything's about odd. It is odd. If I find Judge Belzeos on an agent registration form tied to one of those weird companies from back in the day, we'll say, then I'm going to be like, what? All right, what company am I going to find Judge Cannoni on now? Like, what is this? But I'm not there yet. Just this is not enough. All right? Just this is... It's not that it's not enough. It just isn't... It's odd, but it's only a start. And mind you, the whole reason I didn't do this gratuitously, it's just because a ruling can be something I disagree with, and I will not have a concern level that goes to this. It's when you make a finding of fact that is just so obvious, or like summarize a case or something, and it's just so obviously wrong, where I'm like, wait a minute. Like, it's really helpful to one side for you to be this wrong. Why? Like, why? Let's ask some questions about why. And that's my job, I suppose. I read the documents, and then I have questions. Now, I can't stay up too late tonight. I have to go to bed within the next couple hours. You know why? Because I have to be up really early for this. Tomorrow's a big hearing, and guess what? I have big news. You are going to get HD if the internet works. I don't know how good the internet's going to be. Even if you have internet there, it doesn't mean that your signal where you're broadcasting from is great. I figured things out. I'm going to go, and my motion is approved, so I get to go in early. All right? I'm going to go in. I'm going to hold up my motion. I'm not going to print it out. I'm going to save the trees. And I'm going to be like, hi, I would like to set up my camera. And I'm going to be like, I have not just a form, I have an approved motion. I am a towel. Okay? Then I'm going to do that. And then, the coverage you're going to get tomorrow, you don't understand. I'm going to be a towel cameraman. I'm going to sit there with my camera. Okay? It's going to be on a stand. And I am going to zoom in on Adam Lally and Michael Proctor. And I'm allowed to do it. I'm going to zoom in on him. You don't understand. Then I'm going to zoom to the left. Then I'm going to zoom out when people are asking questions, like Rosemary Scapicchio. Then I'm going to zoom in on the judge. Then I'm going to zoom out. I'm going to film the gallery. I'm going to do all of it. The only thing I'm not going to zoom in on is attorney's notes or computers, because you can't do that. But I'm going to be the towel cameraman, and it's not going to be our webcam footage. I'm going to be in there with, a very formal camera. I don't know if I'm going to patch it through. I got it, so I can patch it through USB, but it drops the quality. I can patch it directly through the HDMI. I have to run it through an external like video converter, and then it will send the HDMI through USB 3 into the computer, and then I can render it. And it will have all the raw data from the actual feed, so it's going to be like, it's going to show you the levels, and it's going to show you some data, the date, the timestamp, but that's fine. I don't care. It's going to be great. I've never done this, and it's the hearing where you want to do this, because I'm going to be able to zoom right in on Adam Lally's face. And I'm the cameraman. I am the towel cameraman. It's going to be great. Now, other people can come and do their own thing, all right? If you did, I hope you did a motion. But I got my motion approved, so I'm going to be there. I'm going to have a nice breakfast sandwich. You know, maybe Mr. and Mrs. Sweeney want to go get a breakfast sandwich. Then I'm going to walk right, I'm going to march right up to that door and be like, I am the towel cameraman. Likely one of them is going to, before I can even say that, be like, oh, it's the towel cameraman. I'm going to be like, you really, you know, like, undercut my joke there. And then I'm just going to go about my day. It's going to be hilarious. I'm just a walking ball of fascinating energy. You should see me when I'm at that courthouse. Everybody's like, hi, Grant. So good to see you, Grant. And I'm like, hi, how are you? I'm a Dow. And they all just beam and smile. Except for Judge Krupp. He kind of looks at me like a little sad-eyed. Well, all right. You know, I was thinking of this. I was actually thinking about, because Judge Krupp had to rule on my motion for tomorrow. And I feel like every time the name Grant Smith Ellis shows up on Judge Krupp's desk, he's like, oh my God, every time I see his name again, he's somehow more prominent. He's involved in more things, like more people are getting arrested. Like, oh God, like, he's like, so he's like, all right, I should not get mad. I should, you know, I'm just going to go about my business. But then when he sees me in person, he just kind of, and I'm like, you know, I try to smile and just keep it calm. But the point is, you ever like find a judge in the Epstein files, and then, you know, you report on it, and then the judge kind of like, from that point on for like years, just kind of looks at you side-eyed, and you kind of, well, months I should say, looks at you like this, and then you kind of look at the judge like, oh, you know, sorry about that, bruh. Like, you're the one in the files. And so that's kind of the vibe between me and Judge Krupp. He's kind of like, what the hell? And I'm kind of like, well, bruh, I didn't put you in the files. You are the one that owned 9.9% of Green Jets in 2011 while you were representing a Russian spy as a federal defense attorney in the district court in Boston. I have questions. So I don't think he's going to really be asking me any questions because, you know, I have questions for him, and I don't think he wants to answer those questions, and frankly, I wouldn't either. You know, that's just how it is, though. I don't know what to tell you. It's not like I went into this disliking the man. He made a great order on December 27th, 2024. I love that order. I'm sure he remembers my laudacious praise. Is that a word? Can you laudaciously praise something? I'm sure he remembers my, like, just extolling his virtues. Okay? I'm sure he does. So, you know, I did not come into this with a predisposition against Judge Krupp. I just was, you know, being a little towel, looking into that 2019 lawsuit with Epstein, and then he drops the documents and as some kind of like threat right before he gets arrested. It probably as an attempt to not get arrested, and then, you know, it was discovery, and so it didn't get made public, but then it was in the Epstein files, and so then, you know, I went through the Epstein files, and I was like, oh shit, he dropped all this shit in discovery, so it was his, like, trump card, so that he would not get arrested, and then somebody arrested him anyway, so, you know, I see the blackmail list now. And I was like, oh, this is bad. And then Judge Krupp talking to the Ruskies in 2011, right when he got a piece of that company. I don't like the damn Ruskies. You can represent whoever the hell you want, but why are you talking to the freaking Russian government in 2011, bruh? It makes me all weird. I'm a towel. So I just kind of, bruh, I got questions. Alright? Listen, all the Democrats, and even some of the Republicans in this state, some of the powerful ones are weird, bruh. They're weird. I don't know how to explain it to you. Like, they're so fake in public. It's kind of like the scribes and Pharisees. They present very clean on the outside, but they have not worked internally on anything. They're filled with human bones and evil. So I see through that. I feel through that. So when I just know. And I even knew with Judge Cannone, I did not like the way that she would smile at me when we were in court. And some people will be like, yeah, but she was very tolerant of your loud typing, and just like you smelled like weed all the time, Grant, and nobody said, because she was telling them not to say shit. Well, I'm sure, but that's not the point. It was creepy as fuck when she was smiling at me, because I was like, oh my God, like she's in on it. And I was like, oh, that's the only reason you would smile, like, oh God. Then I was really scared. I was like, oh shit. Like, this is deep. And, yeah, so I don't know what the hell she's into, but, you know, she's probably on some record somewhere. All these people down the fucking Cape, bro. Like, what the fuck? Oh, that's the other thing I want to talk about. So I used to summer down at Pompanesett in New Seabury. That's where my dad liked to go. All right, turns out Judge Gilday personally owned Pompanesett Market. Now, as a little child, you know, as a little washcloth, I was a little, what you could call, oblivious. So I thought every kid went to, like, an exclusive private playground for the ultra-rich with, like, a market that brings you back to, like, the 1940s and a private, like, day club and, like, nannies. I just thought, I'm a little oblivious. Well, in hindsight, yeah, that was pretty intense. That's like a very seriously wealthy area. And Judge Gilday owned the marketplace. Dude, I used to, in the mornings at like 5, 6 a.m., my dad would like the paper, and I was young, but there was a safe, very safe area, so I could ride my bike. Like, we would stay at a house on a private road right on the beach. Like, my dad must have been loaded. I never really asked how much money he had. But these houses, dude, I remember playing all-star baseball in the rain in one of these houses. It was like fucking 6 stories, like 3 stories above ground, a few stories below ground, and like, oh my God, they were fucking mansions. And they had like patios, so you would like walk out of the kitchen, and then you'd be on this like patio that was, I don't know, like 500 square feet. No, way more. Dude, you could fit like I don't know, 100 people on it. And then the patio was your deck. And then the deck had a ramp, and the ramp went right to the beach, and then it was like your private beach. Like, it was a public beach, but like that was your beach. And I didn't really think that much about it at the time. I just called it the gray house and the yellow house, because some years we rented the gray house and some years we rented the yellow house. So Dad would be like, do you want the yellow house or the gray house this year? And I'd be like, well, I like the yellow house. And he'd be like, okay, well, it's not available for that week, or we'd have to go a different week. He'd let me pick, but I didn't think that much of it. I thought it was very normal. But anyway, at like 5, 6 in the morning, I would wake up first, and I would ride my bike to Pompanesett Market, and I would it's a very fascinating like area of the world. I would ride my bike. There was a nice older woman who was my friend's grandma who lived in this mansion, and I would go to her house in the morning, and then I would walk her paper up to the door, and then she would give me a candy, like a hard candy or whatever, just some like sweet from like a bowl, and that would be my thank you. And then I would ride my bike to the Pompanesett Market, and on the right side of the road was this big pond with snapping turtles, and I would just kind of go on the bridge and look at the snapping turtles. And then I would drive up to Pompanesett Market on my bike. You had to go up a hill at the end, so it was good exercise. And I would park my bike, and the candy store wasn't open in the morning, and the pizza store wasn't open in the morning, nor was the restaurant. And then they had DJs every night, which I always thought was weird. Like, they would just play, like, they had like concerts every night for us. Anyway, so I would go, I'd walk, I'd park my bike, and then you had to wear shoes. Like, you can't walk there barefoot, because the, which now that I realize it was done on purpose, it would cut your feet. It was seashell, like kind of filling on the ground. And I'd walk, like, past the candy store on the left. It was a great penny candy store. Then I would walk straight, and you're in this, like, little village. It's like being in, like, the 1920s or 30s. All the architecture is, like, very, like, it's like kind of like Venetian white, but like scaled down, but there's columns and overhangs. It's very, like, you'd be surprised in that area of the world, even though it's outside, like an open marketplace, like how refined it was. It was like very luxurious. And so I would walk like down this, I'd walk through the sort of part of the marketplace where the restaurant was and you could look over the concerts. And I'd walk behind the gazebo area where we used to eat dinner every night. And then I would go to the convenience store, the general store, as my dad called it. And then I would get him his paper. I would get, I really liked some kind of milk. Like, I forget what, it was like glass bottled milk. So I would pick that up. And then I would put them like on a little, in my bag. And then I'd put them on my back and I would drive back home. And my dad would wake up at like 7:30 and there would be his paper and he'd be happy. And he didn't like make me do it. It was more like I liked the freedom. I was very young. I was like 7 to 9. And he'd be like, okay, in exchange for me letting you ride your bike, it was only maybe like a quarter of a mile. But for a 7-year-old, that's like a world away. In exchange for that freedom, I want you to demonstrate to me you can be responsible. So you're going to pick me up a newspaper. Like, I'm not just like sending you off to the world. He was very responsible, my dad. I'm not just sending you off in the world. Go get the newspaper and you can get the milk or whatever. I forget what it was that I liked, but they had it at the convenience store, so I had a reason to go. Now, what's fascinating is throughout the day, so the convenience store, the general store opened first at like 5, 6 a.m., so you could get the paper. But it was the Cape version of the Globe. So, like, I would pick up the Times for him, the Financial Times. You would get the New York Times and the Financial Times. Those were printed, and they would get them up there for the rich people. But the Globe, they printed a Cape Cod edition back then. They didn't care as much. So we would get like a reduced form of the Globe, and then we would get the Financial Times and the New York Times. So this is like what I read every morning from the age of like 6. I didn't really think of it at the I just thought it was all very normal. I was like, yeah, that's the paper. And so anyway, throughout the day, this marketplace would kind of open up. And what we would do is, like, we would go to the day club, the New Seabury Day Club, and I would, like, swim in the pool or go to the beach. And the waitress or the waiter would, like, bring us our lunch, and I would sit in the gazebo. And then at, like, 4, my dad would be like, okay, we got to go, like, get changed for dinner. And so we would change, and then we'd go back to Pompanesett Market. And then we would go to the mini golf place, and they had a tournament every few days. I forget how often it was, maybe every Friday or something. And then we would practice during the week, and then Friday night we would all play in the mini golf tournament, and the prizes were decent. You either got like a free ice cream at the ice cream store, which was great. I think it was a Ben and Jerry's. It was right in the middle of the plaza. Or if you won the big one, you got like, I don't know, like 4 pizzas at the pizza store. And then, yeah, it was like a full self-contained operation. And the mini golf course was great. It's still there, I'm sure. It's 18 holes. It was really fun to play. And that was my, now that I think about it, that was my, like, very early childhood. And I didn't think very much about it. But now that I know Judge Gilday owned it, that is serious money. I mean, you're talking about generating revenue from some of the wealthiest people you can imagine. These houses, oh my god, I can't, now that I actually think back to what that was like, I don't even know if I can explain to you like what that level of wealth was. Because to me, now that, like, I don't care about money, but now that I look back, yeah, like, I don't know what happened or how my dad got that money, but he was loaded. I mean, I didn't even think about it that way. But yeah, it was also, I just thought of it as like, I don't know, like the house you go to on Cape Cod. I was like 7 though. So that's, I also like would then like tell my dad, like, I would rather go spend time in Dedham. And he'd look at me like I was crazy. And I'd be like, yeah, but it's boring. With, like, at the Cape, like, it's boring, Dad. I want to go hang out in Dedham, like, with my cousins. And that's where I spent, so my family would, like, go down the Cape, and I'd be like, I don't want to go. Can I just go to Dedham? And then I would play Tony Hawk on N64, and I was happy as a fucking clam. I spent more time growing up during the summer actually in Dedham. So that was my life. Now that I think about it, I lived a very interesting life. Like, some of my summer was spent in, like, Chatham, at, like, Chatham Bars Inn, or at New Seabury or Pompanesett. And then now the other half was spent in Dedham on Court Street. And I was happier on Court Street. And that's been the story of my life. I swear to you, I was so fucking bored at fucking Chatham Bars Inn and fucking New Seabury. I loved that my dad was happy. I liked that. But, like, I don't need to be there for a month. And he knew that. So he would be like, right, you can... Like, he would send me with the babysitter. Like, you can go visit your cousins. Like, we don't... It's easier if you're not, like, constantly upset because you're bored. Like, just go do what makes you happy. I'm like, okay. And he was happy as a clam. He loved it. He did, like, he wanted me to be safe, but he didn't understand why I would ever, like, Chatham Bars Inn, for example. Let me just give you a brief aside. We would go to Chatham Bars Inn, okay, and he would rent, oh my God, like, we stayed everywhere from, like, the cottages with the giant chess pieces outside. I would play chess with fucking pieces of chess, like, that were, like, double my size. I would have to, like, grab the whole, like, thing and move it around. He loved that place. And that's how I got to know the McMurphys, actually. I spent a lot of my time in the summer, like, at these, like, weird, like, every night they would, like, have, like, a lobster bake or just all this shit. And the McMurphys were always playing down there. So I'd go hang out with them, and so I've known them forever. They just stopped playing, actually, but they were a great local cover band. They played Jimmy Buffett all the time. I was in heaven. So anyway, what's weird about Chatham Bars Inn, okay, is what my dad would do. And now that I think about it, he must have been very wealthy. Because he would be like, okay, Grant, you have your tennis lesson at, like, 9. And then we're going to go to the cabana at, like, 11. And then at 3, we're going to do, like, this, like, excursion. And then at 5, I'm going to meet you at the veranda. And then we're going to play chess. And then we're going to go to the main dining hall. And you have to wear, you know, a button-up shirt. And then we're going to have dinner. And now that I actually think about what was occurring, like, what that entailed was I would go play tennis, like, with this, I don't even want to know how much it cost, with this instructor who would teach me how to hit the tennis ball. And my dad would, like, sit on, like, next to the tennis court, like, he would just pop in and he would just kind of, like, look and observe, be like, yeah, he's doing a good job. Then I would, you know, go swim in the pool and do kids things. But then once, like, the sun started to go down, it was very regimented. Like, I had to meet him on the veranda at a specific time. He was very serious about it too. Like, you are going to meet me on the veranda at 5 o'clock. Like, he would pencil it in. And then I would go there. He'd be sitting there with, like, a cocktail or, like, a beer. And he'd have a drink. Like, I loved water and Shirley Temple. So one of the two would be sitting there. Oh, and virgin chocolate mudslides, if it was a special treat. So I'd be sitting there, and I'd have my water or whatever with him, and he'd have his beer, and we'd be sitting on the veranda of Chatham Bars Inn. Now, if you know what the veranda of Chatham Bars Inn is, it's like the main part of the hotel, like, on the porch of it, which is like fucking, I don't know, like 2,000 yards long, and you're sitting there on this, like, palatial, like porch, and you're overlooking the ocean, like the Chatham Ocean, and, like, there's, like, people in, like, tuxes serving you, like, cocktail peanuts, and we would play our game of chess and talk about, I don't know, all sorts of crazy shit. Like, he was very interested in just whatever I was talking about. So I would just tell him, like, oh, I read this today, or I was listening to Bob Dylan, or, like, tell me what it was like in 1964, and he'd be like, oh, honey, I don't remember 1964. And I'd be like, well, can you try? So anyway, he was a good man. Loved him a lot. But now that I think about it, yeah, like, my childhood was very position juxtaposition. Like, that, I bored the I loved my dad, but that bored the hell out of me. I was like, why are we here? Who are we helping? Like, what are we doing? Like, I was always just so upset that we weren't, like, helping anyone. Like, what's the point of being here? And he was like, my dad would always be like, honey, it's to relax. Like, you gotta relax. And I was like, I don't like doing that, Dad. And he'd be like, well, you're weird. And I'd be like, yeah. I'd be like, I think you're weird. In a loving, lovable way. He'd be like, yeah, I know. Then he'd kind of pat me on the head and I would just go run away. So anyway, my point is, with that whole story, we went down a little bit of an aside, which is what to do, what to happen. Judge Gilday, and I'm sure, like, my dad knew him. I don't know how. I'm sure. Like, my dad would only go to Pompanesett. You must understand. This was non-negotiable. Like, he could have gone, we used to go to Paris, Prague, Santorini, London, like, Switzerland, I don't fucking know. Like, we would end up in all sorts of random places. Rome, Alaska, California, Hawaii, Texas, I don't fucking know. I would just end up in places. But it was non-negotiable that we had to go to New Seabury, like, for at least a month, every single year. He would not accept any other suggestion. The only input that anyone got, and it was only me who got this input, is, do you want the yellow house or the gray house? And I'd be like, most of the time I would push for the yellow house. He loved the gray house, though. But the thing is, the people who owned the gray house pissed him off one year because they charged him for a cleaning fee for not, now you might think, oh, the kids, what did you do? Like, somebody knocked over, like, a flower vase. Nope. My mother spilled wine, red wine, on the carpets of this mansion, the first floor. They charged my father to replace the entire carpet for the whole house. And so after that, I always got what I wanted, because we always got the yellow house. But before that, he sometimes would override me. But yeah, my mother caused a substantial amount of damage. Fuck if I knew. I remember, actually, now that I think about it, I was very young. I was like 7 or something. I remember my dad, like, in the, like, driveway, like, underground garage of the house, turning to me and being like, these people are going to replace the entire carpet over this spilled wine. Like, I will never, ever, ever give them another dollar. It was brief, but I remember it. He was so mad. So, yeah, and listen, you know, for me, I was very grateful. I loved my dad, but I was autistic. I am autistic. So but I was undiagnosed as a kid. So I didn't understand what was happening around me, because I didn't have anything to compare it to. I just thought it was all very normal. But yeah, my mother did not, in my opinion, treat my father very well. I always resented her for that. Then again, you know, divorces are messy, as people have said, so, and my dad is dead. God rest his soul, so. Just know that I somehow have a connection to Judge Gilday, because my dad insisted on only going to that specific area of Cape Cod when I grew up. Like, only. We would go to Chatham as well. He was okay with that, but it couldn't be in place of. It had to be in addition to. And I never understood. So he must have, there must be some connection between my dad and all of this. And I don't know what it is. And frankly, I don't really want to know, because I love him dearly, and I don't care, okay? But he didn't just pick New Seabury and the Pompanesett market. Like, there's a reason. His friends were there. I didn't know who the fuck they were, because I was like 7. But, and also, I had these, like, Swedish nannies, like these rotating Swedish nannies, and they weren't really nannies. They were like, oh, dude, I remember one day, I was like 8, and the nanny, they were live-in nannies who would rotate every year, and I remember one of the nannies was like in lingerie or some shit, I don't fucking know, and I thought she was an angel. I was like, oh my God, she's come down from heaven, she's an angel. Now that I think about it, there was really no reason for a nanny who was like 19 to be wearing lingerie. So, yeah, you know. So anyway, I don't really know what was going on back then. I don't really want to know what was going on back then. But they were nice. It was like having an older sister. They would like pick me up from school, and then I would watch Full House, and then they would make Swedish meatballs or like whatever for dinner, and that was about it. And then they lived with us, and they changed every year. And they were all very hot. I was like 7 though, so I didn't really think about it. They were all very hot. Blonde, like 5'1", and just very, very hot. They all shared very similar physical characteristics now that I think about it. And they didn't really do any nannying. I wouldn't exactly, I mean, I know how to say It's a Bit Spina. They taught us some Swedish songs, but they didn't seem like they were really trained in childcare. They certainly understood the concept of caring for a child, generally, but there was no, like, let's, sit down for instructive time, like, here's some lessons, there was none of that. No. It was, like, go watch TV, and, what do you want for dinner, and, like, you want to go to the toy store, like, things like that. What can I buy you? So, I'm just saying, I think I now understand who I am, and I think now I understand why so many people kind of keep an eye on me and what I'm doing and who I am, because a lot of people from like my youth, like a very young age, knew who I was. I was like the child of, Rick and Wendy, and they were everywhere. So, like, people who, before they even came to power, were, like, around in those circles, like, they knew me when I was a little baby. And they've seen me grow up. So I think I'm, in some sense, I feel sent to help, because it triggers something in them when they see me involved in this. Like, they back off. I don't know why. They really humanize me. Even in light of, like, it's a serious misconduct. And they also know I have a lot of friends. But there's something odd about this. I don't remember. I don't. I remember, like, some stuff from, like, before I was, like, 9. Like, I remember as early as my uncle getting a hotel from a guy during a bankruptcy proceeding, and me being at the hotel, and I was like 2, and we got these like packaged fake fireworks, like sparklers, and I remember turning, like, it had a red handle, and I turned the white thing on to make the thing sparkle. The hotel was off a main road to the left. And so I remember vividly a lot of stuff until like age 9. The Tokyo or Japan Olympics in like 98. And then it's all black for a very long time. And then I kinda remember some stuff in high school, more in college, more in grad school, and then more now. So, yeah, I don't know what happened, but something odd happened. And all these people, I don't really know what they were doing. It seems to be a very, very tightly connected, very wealthy network. But I don't have it all. And I don't know why I'm so integral to it all. I really don't. I need answers. I will get my answers. But I don't really matter in all this. I have just tried to help, and I hope it's made the world a better place and allowed people to feel more free, less threatened, less under duress. I hope all that has happened. But eventually, as I get older, I want to know what happened to me. Like, first of all, who exactly were my parents? And what exactly was I around for, one, the first like 10 years of my life, but more importantly for the time I don't really remember. From like 1998 till like 2004, 5, like what happened? Like I remember my sister modeling. She was very young. I remember the modeling agency was in Watertown, over the pike near the Doubletree, kind of near Newton, past the Bertucci's. I remember a modeling agency, but that's only because I broke my wrist. And we had to go to the hospital. And so I remember on the way to the hospital, like my sister had to be dropped off at modeling. So I remember that. And then the one, I remembered this today. So I was sitting around with two family members, and one of them, who is not at all in this like world, told me her son went on a yacht with Sheldon Adelson. And I was like, and my mom kind of looked at her like she was pissed, and my mom didn't say anything about it. But I was like, wait a minute, why would your like teenage son be on a yacht with Sheldon Adelson? You know what I mean? And at the time, bro, I'm just thinking like, I don't know, maybe he's got rich friends. Now that I look back, dude, that's weird. Like, that's weird. I probably should tell the FBI about that. Like, that is weird. There's no reason that that child should have been on a yacht with Sheldon Adelson. And the mother could not have made it happen. Like, the person's mother. She was not from that world. Well, my mother could have. That's terrifying. So, like, some stuff's starting to come back to me. And it's a picture that's not very pleasant. It's a little scary. Alright? But that's enough of the digression. I have to get up early tomorrow. We have 10 minutes more in this ruling. I've already found the weakest part of the ruling. Let's do the third-party involvement section again. Let's finish the ruling. Then I got to go to bed because I have to wake up early to see you all again at 9 a.m. for the Proctorgate hearing.
Connection.
All right.
Arguments were not 353. De Los Santos, 405 to 356, satisfy the heavy burden of showing any of the aforementioned parties first. Motion. Because it reasonably could not have, been known to him when he filed it, is that the Commonwealth misled the grand jury by concealing the fact that a third party, KP,
Sheldon Adelson was he's dead. He was a very wealthy billionaire. Like, very wealthy. And he had a yacht.
sent it certain material during the Commonwealth's investigation and in the weeks leading up to the start of the grand jury proceedings. To warrant dismissal, Kearney bears the heavy burden of showing that the Commonwealth's failure to inform the grand jury that KP sent material to the Commonwealth probably influenced the grand jury's decision to indict him. Secretary Fernandez, 483 Massachusetts at 8. Reyes, 98 Massachusetts Appeals Court at 805. Although KP undoubtedly sent the Commonwealth materials she believed evidenced Keamy's criminal conduct, there is nothing in the record to suggest that the Commonwealth's failure to inform the grand jury that she, one of many sources of information utilized by the investigators, influenced the grand jury's decision to indict him. Civilians, such as KP, routinely provide what they believe to be evidence of criminal conduct to the police. Notably, Detective Lieutenant Tully has asserted that, in connection with the at-issue indictments, the video excerpts admitted into evidence were the product of his own internet searches, and therefore independent of KP's input.
Oh, she sent him all of them!
20. Paragraph 7. The court sees no reason to discredit this contention. Even if
Are you kidding me?
Did mislead the grand jury, Kearney cannot show that, on the entirety of the Prand J. Urey record, such failure would have affected the decision to indict. See Commonwealth versus Hunt, 84 Massachusetts Appellate Court, 643, 657, 2013. As discussed in this court's Doolin Justice decision, there was sufficient probable cause for the grand jury to indict Kearney. As such, even assuming the Commonwealth should have informed the grand jury that KP was potentially one source of information, The decision not to do so does not change the fact that there was sufficient evidence of Keamy's own conduct to support the grand jury's decision to indict him. Commonwealth versus Brown, 490 Massachusetts, 171, 186, 2022, concluding that grand jury proceedings not impaired, where the grand jury were presented with sufficient probable cause to issue the indictments. Therefore, Keamy did not meet his burden of showing that the evidence he claims should have been heard by the grand jury probably made a difference in the grand jury's decision to indict him. Ulen prosecutorial misconduct. Kearney argues that the Commonwealth committed egregious discovery violations by failing to timely disclose communications between a third party and agents of the Five. To the extent that Kearney contends KP is part of the prosecution team or agent of the Commonwealth, there is not enough before the court to support either contention. Generally, the prosecution team consists of individuals who have participated in the investigation or evaluation of the case and has reported to the prosecutor's office concerning the case. Graham versus District Attorney for the Hampton District, 493 Massachusetts, 348, 361, 2024. Independent witnesses are not part of the prosecution team unless that witness has acted in some capacity as an agent of the government via the investigation and prosecution of the crime. Commonwealth versus Beale, 429 Massachusetts, 530, 532, 1999. Fact that a prosecutor may have developed a good working relationship with the independent witness does not convert that person into an agent of the prosecution team. /D. at 533. For an agency relationship to exist between the Commonwealth and the individual, there must be, at a minimum, some express or implied agreement or arrangement promising rewards or inducements in return for information. Commonwealth versus Bateman, 492 Massachusetts, 404, 416, 2023. Mere knowledge of the government's desire for information about a crime does not turn an individual into a government agent. Yeah, at 415 to 416. There's nothing in the record before the court that supports a finding the Commonwealth and KP had any sort of agreement. Commonwealth in violation of Massachusetts Rule of Criminal Procedure 14 and Brady. 6. Kearney contends that the Commonwealth's conduct was so egregious that dismissal is warranted. The court disagrees. Dismissal of criminal charges with prejudice is the most severe sanction that the court can impose into criminal aid to remedy misconduct on the part of the Commonwealth. Commonwealth versus Mason, 453 Massachusetts, 873, 877, 2009. Such a sanction is a remedy of last resort where there is egregious prosecutorial or police misconduct and prejudice to the defendant's right to a fair trial, and where the dismissal is necessary to cure the prejudice. Quotation and citation omitted. Commonwealth versus Pina Lara, 104 Massachusetts Appeals Court, 680, 689, 2024. Absent egregious misconduct, or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. Mason, 453 Massachusetts, at 877, quoting Commonwealth versus Sinelli, 389 Massachusetts 197, 2107, 1983. Two parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. Commonwealth versus Kronk, 390 Massachusetts, 4, 198, 1985. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive, and the defendant is prejudiced by the failure to disclose, a motion to dismiss should not be allowed, absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Committee for Public Counsel Services versus Attorney General, 480 Massachusetts, 724, 2018, CPCS, quoting Cronk, 396 Massachusetts at 198. Alternatively, in rare circumstances, prosecutorial. 6. At the hearing, Kearney's counsel clarified that he is not arguing that the material KP sent to the Commonwealth was exculpatory or that the Commonwealth destroyed exculpatory evidence. Nor could he, as he has not offered any evidentiary support to demonstrate the materials to the Commonwealth would have been exculpatory evidence. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden. To establish a reasonable possibility, based on conerty evidence rather than a fertile imagination, that access to the evidence would have produced evidence favorable to his cause. Internal quotations and citations omitted. Commonwealth versus Key, 449 Massachusetts, 554, 2007. That is, the defendant must establish a reasonable possibility that the lost or destroyed evidence was in fact exculpatory. /A at, citing Commonwealth versus Cater, 432 Massachusetts, 418, 2000. Misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights, may give rise to presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. See Cronk, 396 Massachusetts at 198 to 199. The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. Quotations as citations omitted. CPCS 480 Mass at 724 A. Kearney has not shown that he suffered any actual prejudice based on the Commonwealth's late disclosure. This is not a case where the discovery was provided to the defense on the eve of trial. Rather, the discovery was provided over several months in the latter half of 2025, at least a year before Kearney's trial is set to begin. Although the Commonwealth should have disclosed the communications sooner, the failure to do so does not warrant dismissal because such conduct does not reach the high threshold of egregious misconduct. Commonwealth versus Edwards, 491 Massachusetts, 1/9/2022. C. Brangan versus Commonwealth, 478 Massachusetts, 361, 366, 2017. The standard for prosecutorial misconduct mandating the dismissal of an indictment is high. Even if he had shown prejudice, dismissal would not be appropriate as it is a remedy of last resort. See Commonwealth versus Trepania, 105 Massachusetts, Appeals Court, 712, 716, 2025. Kearney has also not shown that the Commonwealth's conduct was so egregious, deliberate and intentional, that prejudice should be presumed. Kearney has not provided evidence to support the notion that the Commonwealth's delayed production of KP communications has cast such doubt as to poison the entire investigation. CPCS 480 Mass at 724, quoting Commonwealth v. Hine, 393 Mass, 564, 571, 1984. Consequently, Kearney has not shown he has been prejudiced in such a way that will elude him from obtaining a fair trial. See Commonwealth versus Lamhugh, 391 Massachusetts, 301, 3100, 2313, 1984. whether dismissal is warranted, turns primarily on the ability of the defendant to obtain a fair trial after, and in light of, the impropriety. 2. Evidentiary hearing. In light of the foregoing, request for an evidentiary hearing is also to be entitled
come
to
on!
an evidentiary hearing on a motion to dismiss. He must make a substantial preliminary showing that felony was knowingly presented to the grand jury by the Commonwealth or one of the agents. Commonwealth versus Salmon, 387 Massachusetts, 160, 166. 1982. As discussed above, Kearney has not made such a showing. Order. Foregone reasons, Kearney's motion is denied. Christopher P. Belezos, Justice of the Superior Court, dated August 25th, 2026. Kearney seems to make a passing argument that he has been unfairly prosecuted as a result of the Commonwealth's misguided obsession to get Turtle Bay. Docket number 104, page 30. To the extent that he does, such argument fails. Kearney has not presented any evidence to support a claim that the Commonwealth, or any of its agents, has discriminatorily applied any criminal law to him. See Commonwealth versus Rodriguez, 496 Massachusetts, 627, 633, 2025, discussing selective prosecution and selective enforcement. In any event, whereas here, the indictments are supported by probable cause, the prosecutor and other law enforcement officers have broad discretion in deciding whether to prosecute an individual. See Commonwealth versus Cheney, 440 Mass, 568, 574, 2003. Commonwealth versus Franklin, 376 Mass, 885, 894, 1978. Commonwealth versus Newton N., a juvenile, 478 Mass, 747, 755, 2018. Commonwealth versus Moore, 93 Mass, App, Counts 73, 77 to 78, 2018. 8.
I'm offended. That's ridiculous. Won't even give him an evidentiary hearing? I mean, that is just complete. He's denying him. First of all, the court's like, well, there's not enough evidence on the record to make a determination about whether Kate Peter was a government agent. Now, as to Aiden's alternative request for an evidentiary hearing where maybe I could figure that out, no, we're not doing that. No, you see, we're not going to do that because I don't see anything about knowingly false testimony. Excuse me. This is ripe for appeal. And you know what that means? If Deitch wins and this goes up on appeal and it gets stayed, no trial before January of 2027. This is literally an invitation to can't take that call right now. This is an invitation to appeal. And that's my lay opinion. I want Brother Counsel to look at it, and I want Melanie Little to look at it. If Attorney Melanie Little and Brother Counsel and I, two lawyers and a lay towel, all feel the same way, yeah, there's something wrong here. And I knew it. People are going to be like, wait a minute. All that stuff Grant was saying about Hybel and Kate and the government agency doctrine, that was operative to the ruling? Yeah, dude. I tried to tell you. They're going to try to argue she's a civilian. You gotta meet the government agency standard. You get the blueprint, although it's persuasive, not binding, from Hybel, and you loop Hybel through her actions, and you gotta set the record. Now, Betterow was going in that direction, and he did go in that direction. I just don't think he thought, and I don't know what Mr. Betterow thought, I just don't think he realized how weighty the classification of Kate Peter as a civilian versus a government agent under the doctrine of Hybel is to the outcome. It's determinative. It is the operative fact upon which all of this turns. He treated her like a civilian. Wrongfully so. I think Mr. Betterow, at a bare minimum, gave the court enough to grant an evidentiary hearing, but to deny him the opportunity to give the court what it said it doesn't have, enough information to make the agency determination. Come on! Come on! What are we doing here? I don't know. That's politics, not jurisprudence. That is why Habermas is such a ferocious critique, has such a ferocious critique of legal rationality. You know why? Because this is, much like Judge Gilday, a ruling that was decided and then written to build the facts and law to get to the conclusion. And that is not how jurisprudence works. Because in my opinion, an authentic analysis on the factual record of Kate Peters' role, at the very least, merits an analysis of the government agency doctrine, and if you don't have enough there, then ask for more. And then, if the whole ruling has to then be reevaluated, whether you want to establish that there was going to be probable cause or not, in light of the grand jury knowing about Kate's role in the investigation, set that aside. Do that analysis after. You have to do it in light of the correct foundation, accurate to the factual record. This is not a question of opinion. Kate Peter either is a government agent for the purposes of this doctrine or is not. And he ducked the central question and then made a ruling on a false pillar. Not shaky, false. And that screams problem. That screams, hey, look at me. Everybody look, there's something really wrong here. It's a huge red flag. Huge. I can't prove it yet, but I know there's something wrong here. I know it. I can't prove it, but I know it in my heart of hearts. And once I have that feeling, I'm going to find it. I'm going to find the document. There's always one. Everybody always leaves at least one smoking gun. Because you can't plan 15 years into the future, or 20 or 30. You left a paper trail somewhere, and I'm going to find it. Whoever the trial court is at the trial, and I've already redressed my grievances, or petitioned to redress them. Whoever assigned Judge Belzeos, Judge Gilday, and Judge Cannoni to those cases, we got some questions. We got some serious questions to ask. Now, Judge Cannoni set that aside. We need to figure that out. But the special assignments in particular of Gilday and Belzeos, we got to find out who. We have a right, I think. We have a right to find out who in the trial court made that decision. We deserve the public records. Kyle? Hi, Mimi. You're so wonderful. Mimi's wonderful. Yeah, we have a right to know who specially assigned these judges. If we find that out, I think we can get somewhere. Yeah, we're close. That may well put it all together. But that's like a complete stonewall. Until we get the documents, I don't know. I have no idea. It could be the RAJ, it could be some secretive counsel, I don't know. It's very taciturn. A lot of agencies of government are taciturn. The courts they're like a constitutional branch of government. They're very taciturn with that kind of stuff. So, I don't know what to tell you. Something's off. I read the whole ruling. It centered, Kate Peter is the story here. Her role, but it's not Kate Peter, it's the question of whether she's under the doctrine of government agency, whether she falls under that doctrine, which is not like a government agent. That's a legal term of art for having agency as like an extension of the prosecutor's office or the state police. If you get that designation, I mean, that changes everything. Kate Peter's not a civilian. She's a lot of things, but she's not a civilian witness. So, yeah, I mean, that's it. That whether Betero wants to explore it, I don't know. I would, but I'm not a lawyer. I did go to law school, though, and this is not legal advice. All right, you got me for like 10 more minutes. We're doing the Farwell motion just went up, all right? So we're going to do that. Now, you might be saying to yourself, Grant, how do you do this? Do you just sit there? Like, and do you just camp on the docket? I mean, I don't camp the docket, but I refresh it multiple times per day. And yes, it costs me like $2 per time, but it's important to me. And so I see everything the second it goes up. I'm like, but with federal dockets. And I don't use Court Listener, I use Pacer. So you put that document up on Pacer and it's not sealed and it goes up, I'm going to see it the second it goes up. Maybe within like an hour. Let me do a quick reminder, though. So a lot of people have been asking, Grant, like, when it's the moment and, like, we can support you, what is the best way to do so? And please don't do it if it would be a burden or if you already bought the book. But if you would like to know how you can support me right now, I have a new book out. It is called Lost Days in Norfolk County, The Rise and Fall of Michael Morrissey's Machine. Now, I am not Tal Vanilla, and this is not Tal Shopping Network. However, I will tell you, if you put exclamation mark book, hi T.A. Sarah, you're doing a great job, 20 billion bonus points for being a T.A. Sarah. Now, if you type exclamation point book in the chat, it's going to take you to a link to buy Tal's book. Now, you can get it for free. I'll give you the Google Drive link. But if you want to support me and you want to help this book continue rising up the charts, it's about to break the top 40,000 overall on Amazon. You can purchase this book. Now, when you purchase it, I got it from my Nana. So when you do that, it gives you this link, and you don't need a Kindle. It's an ebook. It's going to open it right up on your machine, and you can just start reading the book. Now, I was already reading chapter 7. It remembers where you are when you're reading. But this is just a preview. Okay, I wrote this book. I actually wrote the text, then I interpolated it into an audiobook, then I made it back into a book, and then by hand created the Kindle version. It was very hard. So, yeah, enjoy it. It's called Boss Tweed Days in Norfolk County, The Rise and Fall of Michael Morrissey's Machine. It is $9.99, okay, on Amazon. And you can find more information at the link in the chat. And if you did buy it and read it and you liked it, please consider giving the book a review. You can see what its number, so it's fluctuate. Last night it was 54,000 overall. Now it's close to like 42,000 overall. And it's in its category, it's number 2 in leadership, the number 1 best new release, number 8 in campaigns and elections, and number 11 in practical politics. So God bless you all. Get a copy for Kofi. Get a copy for, your mom. If you want to help, get a copy for your aunt, your Kofi. How did you like the book? Kofi's a dog, but he's going to learn how to read just so he can write. You know what? When this book gets printed, Bunny, can we put Kofi's paw print on the back of the book, and above it, can we be like, I, Kofi the dog, loved this book, and then people are going to be like, what? What the fuck? They had the dog read the book. It's going to be great. All right, let's go to the Birchmore motion. And there are other ways to support this channel as well. I should do this every couple hours. God bless all of you who contributed towards the Super Chat. We got 6 out of 10 towards our goal. That counts, all right? That means something, ladies and gentlemen. I appreciate all of you. God bless you. We're going to go to the Birchmore Farwell motion. Then I'm going to bed because I got to wake up early and cover another major bombshell hearing for you with my professional towel camera. Yes, Kofi's going to sign the back of my book and endorse it. Excellent job, Kofi. It's called a blurb, Kofi. You're going to blurb it. All right. Have you ever blurbed something before, Kofi? This is going to be on the final. T.A. Sarah will be. Yes, Kofi approved. All right. Now, Kofi, have you ever blurbed something? All right. Now, listen. This is a very important concept in book writing. I'm going to give you the book. Okay. You're going to, look at the book, do whatever dogs do with books. Then, Bunny Towel Mom's going to say, Kofi, what do you think of the book? Then you're going to bark at her. She's going to translate it and then write down what you think of the book. That's called a blurb. And then we're going to put your paw print under it. You're going to be a superstar, Kofi. All of your doggy life has led up to this. You are the first dog in human history, or doggy history, or towel history, as far as I'm aware, that has been asked to blurb a book. You don't understand. Kofi, you are going to actually go down in history. You are going to become the first dog to ever blurb a formally published book. And the publisher's going to be like, we're not doing that. And we're going to be like, no, this is non-freaking negotiable. Absolutely non-negotiable. His paw print and his summary is going on the back of that book. I don't care what academics you want to put on the book, what authors, I don't care, what journals, I don't care. Nope. Kofi the dog, what lawyers, Kofi the dog is going on the back of that book as a blurb, and it's literally, it's going to be in my contract. My literary agent is going to be Tripoli Bob, and I'm going to be like, listen, do not cave on this point. Bring me into the room, I will yell at them myself. This is a great plan. Ellie the goat will write a letter of recommendation. Mimi, this is... All right, okay. All right. I got a plan. What we're going to do is, we're going to have Ellie the baby goat, okay, do one blurb. And then we're going to have Kofi, the dog, do another blurb. And then I can say that my book is endorsed by Ellie, who is a baby goat, and Kofi, who is a dog. All right, we're going to baffle the ever-loving hell out of the publishing industry. Now, when people interview me, they're going to be like, I really found this book fascinating. But before we begin, Kelly Ripa or whatever the hell they call the talking head these days, animatronic, whatever, they're going to be like, listen, I loved the book, but when I was reading it, I came across on the dust jacket these blurbs, and, I saw this lawyer on there and these professors, and I got to the end and I read, these endorsements by Ellie and Kofi, and there's like a paw print and a hoof print or a goat print under their signature. Did you have a dog and a goat endorse your book in the form of a blurb, and then did you have them sign it with their paw prints and hoof prints? And I'm going to be like, well, you see, in the world of literary criticism, we really have to think about the postmodern implications of trans-species hermeneutical reconstruction. And frankly, in the absence of the input of our let's say, Homo sapien-based friends, I think we would be doing a disservice to the wide range of metacognition that exists throughout God's kingdom. They would be so freaking baffled that they would be like, oh, the dog must be adorable, right? And I'd be like, yes, Kelly Ripa, the dog is freaking adorable, as is the baby goat. Not really the point I was going for there, but, you do you. You know what? Like, that's cool. But my point is, yeah, I got a plan. I've already thought about this, all right? Excellent plan. A dog signature. Can you believe it? Oh, Sandy, thank you so much for posting the book link. You can at any time find out how to buy Towel's new book by just doing !book in the chat, and it will take you right to Amazon. It's available in 12 countries through the Kindle store. If you cannot get the book, just let me know. I will provide you a free copy. It's literally free, but people have been choosing to buy it to support me, which is wonderful. God bless you all. Buy multiple copies if you want to support me. I don't know if you're allowed to do that. Apparently you can only buy one, but what if you want to give? Oh, you have to buy it for others. Okay, so if you listen to me, say you're out there and you're like, you know what? I want to catapult this book to stardom. You just go over to this tab here, right, on the right on Amazon, and you click buy for others, and you can buy as many copies as your heart desires. If you want to send this book single-handedly, apparently to the top of the charts, you can, like, that's what colleges do. The libraries, or like a book signing event, they just buy 100 copies, 1,000 copies. You want to send this book to the top of the charts, I'm not going to stop you, but don't do it if it would be a burden. You only do this if you're like, you know what, I'm ready to make a point to society. It's not going to take, don't do it if it would take food off your table or deter from you caring for your animals or your family. But if you want to do it, now's the time to do it, all right? Because the way Amazon judges it, well, a lot of different things, but it's like the first couple weeks and the first couple days in particular are very important. So if you've been waiting for that moment, if you're like, oh yeah, hell yeah, I can feel it, I'm called to do this, you go right onto Amazon, you buy that book for as many people as you want. God bless you for doing so. And by the way, it's not about me. I've never published like a book. I published a satire one time because I wanted to mock some other guy who wrote a book with no words in it, and I just thought it was funny to mock him, which is what art can be sometimes. But I didn't intend to sell it. I was making an artistic point. This book, first of all, it's available for free. Second of all, it's not about me. Why would I try to promote something that I'm giving away for free? I don't really care. I want you to read the information. The fact that it's getting prominent means that more people will learn about the information. And that, literally, I'm going to bed tonight. I need to go to bed soon. But I feel so empowered and I feel so inspired. And there are so many people who are hurt and wronged by this machine. And I can't go in, like, individually into thousands of lives and help people. I can't. So I have to reform it systemically, and the only way to do it is if people understand what happened. And I think this book, this is just the first edition, it's a work in progress, but it has a lot of good primary sources. I actually looked at it, just my opinion of my own work. I looked at this book. There is way more than $9.99 worth of primary sources, just in the amount of cost to download me from the documents from Pacer. So, and the research is worthwhile. I mean, there's some great primary sources in there that you would have had to really dig to find. So I think the value in this initial version is you get to see where this project is starting, all right? This is not the published book, like in print. I gotta do a lot of things to get there. But it's a great Kindle version of the book. I think it's accessible. It's basically perfectly formatted. The index did not translate to Kindle well just because of how the index was done by page number. I will fix that in future editions. There was one little compression of my author's note signature. It looks fine, but I want to fix it. It should be on 3 different lines, not 4. And then there was one part of the index page where there was one extra space before a chapter, and it didn't line up perfectly. But overall, I really liked how it came out, and all of those printing errors were not in the original text. It was just a consequence of importing the text into Kindle format. So there you go. My name is Grant Smith Ellis. We got one motion to go, then I'm going to bed because we have a very big day tomorrow. This is the U.S. government's new motion up on the Farwell docket. Let's see what U.S. Attorney Leah Foley has to say. As you know, if you watched the press conference earlier, she was where... Actually, before we read a motion from U.S. Attorney Leah Foley, you want to hear her quote earlier? Tell me that you don't think U.S. Attorney Leah Foley is a boss. Have you ever met a boss, this much of a boss in real life? Ever? Tell me who you've ever seen that wears handcuff necklaces to a press conference about arresting another public figure in Massachusetts. Hold on. Hold on. I want to be able to pause it before I begin so I can full screen it. It auto-played. Imagine being U.S. Attorney Leah Foley. She goes out there this morning at 11 a.m. I was covering it live. You can find the video on this channel. She's announcing she's arrested yet another corrupt Democrat in Massachusetts. And she's wearing handcuff necklaces, a necklace with handcuffs. And wait till you hear what she says. Jackson Unleashed said, "Goats are running around a man. The bodies are at his feet. A golden towel is held. Mr. Smith Ellis is his name. The McAlberts are vanquished." God bless. Hey, I can reply to this one, Jackson Unleashed. There you go. People are learning that if you cuss in the super chat, it doesn't let anyone reply to it. It's its way of letting you send a super chat with a cuss, but kind of warning you, well, nobody's going to be able to reply to it. U.S. Attorney Leah Foley, ladies and gentlemen, listen to what she had to say earlier via coverage on Towel News Network. My name is Grant Smith Ellis.
We go out, we follow the evidence. Wherever that evidence leads us is where we land. And if that evidence leads us to the doorstep of somebody who is an elected official, to a doctor, to a teacher, to a law enforcement officer, nobody gets special privileges just because of their titles or their positions they hold.
How about them apples? You think I'm a boss, she's a boss. All right, so speaking of U.S. Attorney Leah Foley, let's take a listen to the newest motion from her office. Then I'm going to bed early because I have to be up for a 9 a.m. explosive Proctorgate hearing. I will set that live stream link up soon because once I'm off tomorrow morning, You're not going to see me again until I'm in that courtroom as cameraman towel. All right, so let us begin. Oh, by the way, T.A. Sarah, this is a special voice in your honor. It is the T.A. Sarah voice. Kevin from South Boston said, can you start over? I'm late for class. Also, Chloe ate my homework, but she's a good dog. Hi, Pats are back. Hi, Kevin from South Boston. You're all doing very, very good job. Excellent. Kevin from South Boston, you get 40 trillion billion Googleplexes worth of bonus points. You got to look up how many zeros that is. Tell T.A. Sarah after you write the number out. Even though you're late, all right, just for being a Kevin from South Boston. Now, T.A. Sarah, you get 50 trillion bonus points because this reader, we're calling this Reporter Towel T.A. Sarah, okay? The name on the software I use to make the accessible sort of readings of these documents is Sarah. So this is Reporter Towel T.A. Sarah covering for you the latest motion from U.S. Attorney Leah Foley in the Sandra Birchmore Matthew Farwell case. Take it away, Reporter Towel T.A. Sarah.
United States District Court, District of Massachusetts, United States of America, versus Matthew Farwell, criminal number 24-10259-DJC, leave to file granted on August 26, 2026. Government's reply in support of motion to exclude certain opinions by Dr. Thomas Andrew, M.D. The government submits this memorandum to respond to the spurious allegation of misconduct included in defendant Matthew Farwell's response to the government's motion to exclude testimony by Dr. Thomas Andrew, M.D., ECF number 224 at 11-12. Farwell alleges that government counsel, FBI agents, and Dr. William Smock, M.D., converged on the assigned medical examiner during meetings and pressured her to change the initial ruling that Sandra Birchmore died by suicide. IDU 1 Farwell claims that Dr. Andrew, who did not attend the meetings, will testify that this must have happened. Dr. Andrew's speculation about what happened at meetings he did not attend is plainly inadmissible. The court should exclude Dr. Andrew's opinion about the government's meetings with the medical examiner, Dr. Maria Del Mar Capo Martinez, because 1. Dr. Andrew has disclosed no specific experience that would make him qualified to opine about alleged pressure applied to Dr. Capo Martinez. 2. A conclusion about alleged witness tampering is not an appropriate topic for expert testimony because it is not a subject that is beyond the understanding of the average juror. And 3, the court should reject Farwell's efforts to confuse and mislead the jury by offering expert testimony where there is no evidence to prove the underlying facts. 1. Dr. Andrew has disclosed no experience or methodology for his opinion that Dr. Capo Martinez's ruling was the product of government pressure. Farwell claims that Dr. Andrew is qualified to opine that Dr. Capo Martinez revised her ruling to undetermined because prosecutors, FBI agents, and Dr. Smock pressured her to do so during meetings in 2024 and 2026. ECF, number 224 at 12. The problem is, Dr. Andrew fails to disclose specific facts about his experience that support his alleged ability to determine when law enforcement has caused another medical examiner to change his or her ruling. See Federal Rule of Evidence 702. The sole basis for Dr. Andrews' alleged expertise is his experience interacting with prosecutors who have pressured him to change his determinations as to cause and manner of death to suit their theory of the case. ECF number 224 at 12. This does not demonstrate that he is an expert who can detect when other medical examiners are the subject of pressure allegedly applied during meetings with law enforcement. His expertise boils down to a statement that someone pressured him so he can reliably detect whenever it happens to another medical examiner. But that is not the standard for admission of expert testimony. C. Rodriguez v. Hospital San Cristobal, Incorporated, 91F, 4th 59, 70-71, First Circuit 2024. Nothing in either Doe-Bear or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the Ipse Dixit of the expert. Indeed, Doe-Bear made clear, an expert's opinion must be supported by appropriate validation and rest on more than subjective belief or unsupported speculation. Quoting General Electric Company versus Joyner, 522 U.S. 136, 146, 1997, and Dober versus Morel Dow Pharmaceuticals, Incorporated, 509 U.S. 579, 590, 1993. Dr. Andrews' disclosure does not help the court understand the basis for his claim that he can know when another medical examiner's opinion is the product of pressure. Dr. Andrew has failed to explain the methodology or process he uses to determine what other medical examiners are thinking when they decide to change, or not change, a ruling. He fails to explain why his so far unidentified anecdotal experience qualifies him to draw conclusions about what other medical examiners have done in other cases that do not involve Dr. Andrew. Ultimately, Dr. Andrew claims to offer a remarkable opinion. If taken at his word, he can know the effect government counsel had on a medical examiner without participating in the interaction or identifying the clues he pieced together to gain that knowledge. If he can do this, it would be an extraordinary ability. Therefore, the government is entitled to examine Dr. Andrews' qualifications and learn about what must be a unique methodology. To that end...
Your Honor, he's a psychic apparently, and we'd like to volunteer him on his psychic abilities. Oh, they're pissed at him. They're like, Your Honor, he must be a psychic. He's clairvoyant. We want to study him. Let's bring him in for a voir dire. They're like, but they don't want to outright call him a psychic, so they're like, Your Honor, if he can know the effect that a government counsel had on a medical examiner without participating in the interaction or identifying the clues he pieced together to gain that knowledge, it would be an extraordinary ability. And Your Honor, in that case, we're really entitled to examine Dr. Andrews' qualifications, and we really need to learn about what must be a very unique methodology. That is dripping with so much sarcasm you could serve it on a platter to someone who needs a good dose of catharsis. Oh my God! Listen, sometimes people get catty in court motions. A catty federal prosecutor is freaking hilarious. Are you kidding me? They basically just straight kayfabed calling him a psychic. Where most people would say, Your Honor, the expert witness has claimed skills in clairvoyance. We would like to further examine the most astounding what must be the most astounding scientific foundations for a non-temporal capacity for a human to read the minds of others. That's sarcasm. This is, Your Honor, listen, you know what? This expert simply has a range of abilities that are beyond our ability to, we can't even understand them, Your Honor. This is simply extraordinary. They have invented, the Dr. Andrew has invented a new form of science, okay? And this methodology, Your Honor, we have to examine it, okay? They never say he's clairvoyant. They never say, oh, it's brilliant. Now this, you can sit down, after writing this at one of those fancy schmancy bars. I'm not trying to be pejorative here, but the Beeswax bar in the South End or wherever it costs like $400 to go for New Year's Eve, the Bees Hive or whatever. You can sit down in one of those swanky restaurants, all right, after writing something like this. Now, frankly, my restaurant would permit cigars, all right? So you sit down with a cigar, after writing something like this. You kick back. It's like being at the Black Swan at Oxford. You know, you write something like this and you're like, yeah, I'm good at what I do. Yep. And then you enjoy that 5 minutes. And you're like, yeah, I don't think people will even be able to appreciate that. And then you start thinking about, wonder if anyone will be able to appreciate that. Oh yeah, there's that guy who's a towel that reads all my motions. I think he's a little bit, you know, let's just say unaccountable to the system, but he's hilarious. And he's very respectful and he loves America and he hates the commies. So, you know, he's probably going to get it. But I don't know if anybody else is going to get it. Oh, that's right, he's going to read it. Oh, I should watch that. It's going to be freaking hilarious. Damn right it is. This, ladies and gentlemen, this is better than the finest wine. It is better than the highest threaded satin, some type of Turkish, Egyptian, I don't fucking know what rich people like, sheets. It's better than waking up at the Four Seasons in Rome, having conquered the world and watching and having watched Caligula and the Canaanites and the people from Carthage and New Canaan all fall. Okay? It's like, it's better than sitting, oh yeah, I went to Portofino one time, the restaurant or the hotel where Katharine Hepburn used to go, Hotel Portofino, and their pool was only salt water. And I sat there and they used to bring me breakfast. Like, and I used to sit overlooking the Portofino Harbor, and I was like 9, and I was like, oh yeah, this is the life. I was like 9. I was like, where am I? What am I doing here? Why am I, that's a nice boat. Why am I here? So anyway, my point is, this is like sitting like that, you know, you've done a good job, but you actually earned it. You didn't have to traffic anyone. You didn't have to, like, run a brothel. You didn't have to, like, move weight. You didn't have to get people addicted to Fent. You just genuinely helped humanity, and you did something that, from a literary perspective, is worthy of being enshrined in the canons of the great works. It's great. I love it. If I could write... This is sublime. Okay? This is what good humor is. Okay? Humor exists in the space between what someone means and what they say. This person was like, I'm going to show you humor, Mr. Smith Ellis. I'm going to show you, oh, you think you understand humor? No, I'm going to show you. We need some levity. This has been too intense. This has been very intense. And, by the way, Farwell opened the door to this by having his expert apparently proclaimed to be a psychic. My point is, I love everything about this. As long as I live, I will never, ever, ever come across a piece of intellectual humor in the form of a federal criminal motion from the U.S. Attorney's Office that is as good as this. Show, don't tell. Oh, Shakespeare, eat your heart out. He had some body innuendos, you know what I mean? Which, frankly, I always thought was a body innuendo. I thought the very word body innuendo implied, you know, doing things with the body in the endo, you know? So I was like, Shakespeare was a bit of a pervert. Let's just be, come on, he was a freak, all right? So I was like, he invented the term body innuendo. So I was like, dude, he was just thinking about, you know, bodies and ends and, you know, things going in. That was Shakespeare for you. You ever actually read Shakespeare and, like, looked at the amount of sexual puns that Shakespeare makes more? First of all, it was a problem for James Joyce. This man, in the first paragraph of The Wake, is talking about Britain's peninsulate war, like the peninsulate of Brittany, and spelling it P-E-N-I-S-U-L-A-T-E on purpose. And he was like, yeah, it looks like a dick. What? James Joyce? You're supposed to be, like, the most refined literary, like, apex of all human history, and you're writing about penises. Really? Come on. Did all these people go to the same frickin', like, the ridiculous, like, school that teaches you how to be not the federal prosecutors, I'm talking about Shakespeare and James Joyce, where you learn how to be an erudite, syntactical, refined, elegant writer, while at the same time just hiding sexual puns in plain sight. Have you ever read Twelfth Night? Have you ever read Twelfth Night and then gone to see the play, and then during the middle of the play, while there's an intermission, gone outside and made a joke about yellow stockings that made people laugh? Well, you should try it sometime. It's freaking hilarious. So anyway, my point is, you read a lot of Shakespeare's plays, it's mostly about sex. I mean, he doesn't talk about it openly, but that's kind of like what the art style was like. That's a waste of good intellectual talent. Let lawyers call people psychics and mock them more often in briefs. You hear me? That's what this world needs. If we listen, U.S. Attorney Leah Foley's really figuring this out. All right. First of all, when prosecutors work really hard, just give them a few days off, because then when they come back, they're even more mad. Second, let them, let them flex on the bastards a little bit. You gotta let them flex, because if you just make them be stuffy all the time, they become robotic, and they're not robots. They're not dispassionate robots. Let them flex on the bastards. Let them have a little fun. And I'm not saying take things lightly. You know my standard: 20% entertainment, 40% education, 40% information. There's nothing wrong, though, with that. That gets your brain working. It's good writing. It's great humor. 10 out of 10 joke. Puts Dave Chappelle to shame. All right? Every comic in the United States except for Jolene should retire. That is great. I love it. I love it. I want to frame it. I have found the greatest joke of all time. It's better than a joke. It's like good jazz. Oh, I'm in heaven right now. This is great. Kudos. Kudos to this writer. Who wrote this? Who wrote this? First of all, I'm quoting that. I'm going to make a whole ode to this after I go to bed. Who wrote it? Tori Cummings? Oh, Brian Fogarty. All right, Mr. Fogarty. All right, sir. Now, this man, now, I think Elizabeth Riley's motions have been good. Tori Cummings' motions have been really good. I would hire them all. But, I'm telling you, right here, Brian Fogarty, we get something special in him. Don't let him go to the private sector. Don't you do it! We need him. Listen, you give him anything he wants. You promote him all the way up. Well, keep him working, but keep him writing. But you keep him around. He's really good. 10 out of 10. Great hire. Good job, T.A. Sayerba. Yeah, so great job. 10 out of 10. Brian Fogarty has written the greatest literary commentary on a defense expert being a purported psychic that I've ever seen. You think you know how to call someone a psychic and mock them, but you have no idea. All right? Oh, they use the word divine! Oh, this is divine! Importantly, the methodology or process he uses to divine the application of pressure applied to any other medical examiner without observing the interactions between that medical examiner and any prosecutor or other member of law enforcement. Oh, it's sublime, and it's a pun on divine. Oh, that's it. That's it! I have met my intellectual match, and his name is Brian Fogarty. I always knew there was one out there. I knew it. I have met my intellectual equal. I may even be surpassed by this man. All right. That's it. Put me in more rooms with this man. He'll make me smarter. That's it. Oh, of course he had to use the word divine, too. I mean, makes my heart aflutter. I've never been so inspired by legal writing. I don't know what to say. I have never been this impressed with with someone calling someone else a psychic in a legal filing in my life. First of all, you don't come across that every day. Second of all, it's not normally relevant to any type of legal argument that anyone would make ever. Third, if you're going to do it, ladies and gentlemen, this is your European cathedral. This is your works of Shakespeare. This is the Kubrickian canon made manifest. If you are going to call someone a psychic and it's legally relevant and somehow material to the argument in your motion, you go to page 3 of the USA's reply to Matthew Farwell's motion regarding Thomas Andrew, okay? You go, it's actually the Sir reply, okay? You go to page 3, you go to the first full paragraph, and you read the whole thing. That is your guidebook. Forget the blue book. Forget the APA style guidelines. It all goes out the window. This man has reinvented sardonic commentary in a legal motion. Now we're talking. Now we're talking. You other lawyers. All right? Keep up with the Joneses. You know what I'm saying? Excellent. Excellent, excellent. 10 out of 10. Oh, God, we needed this. I needed my faith restored in the legal profession. We were getting there. U.S. Attorney Leah Foley's offices were really good. You don't want to F with them. They're really, really good. Best of the best. Very effective and very good. And they don't miss. And they're not lazy. And they do it all by hand. No shortcuts. And their production rate is almost as good as mine. It's like mine. They can bang out thousands of pages of motions in like a week. They're really good. They're scary good. And they have a lot. You think prosecutors on the state level have resources. These people have unlimited money. I've never seen anything like this. It's so good. I'm not talking about just this paragraph, but the case they've built here is like a $50 million case. It'd be probably closer to $100 million. I've just not been alive for the bigger cases. I've seen a lot of money spent on federal prosecutions. I've never seen anything like this. You must understand, just the billable hours on these motions are in the millions. Millions of dollars. Not to mention the FBI time, the expert witness time, the medical examiner's time for the FBI, the outside experts, the interview, oh, God only knows, the prep, the proffers. You're talking easily close to $100 million in man hours total. Easy. Billable, the actual bill for this trial, if people only knew. I would say if you combined everything from 2021 through 2026, everything, whenever it started, you're, oh yeah, 50, 75, 100, 150 million dollars. That's not an over-exaggeration. That might be low. When they come for you, they come for you, and they do not miss. Also, Mary, thank you so much. Yes, Judge Belzios did openly declare his conflict with Canton, and then kept going on the case, surprisingly. Let's continue with this motion. I'm going to write this up after we finish. I just love this paragraph. Actually, you know what? Let me write it up now. I'm having one of those moments of inspiration, you know. When you find that it's all muse, you may as well just run with it. Alright. Also, I may not play any music today, just as a heads up, because that means if ads run, I'll be able to actually get the ad revenue for once. I have very low ad revenue because I give it all away playing music, which is fine. But today I might, since I didn't open with it for the hearing, I might just not play music, just heads up. Listen, I just have to write this up. Listen, you lawyers. If you want to accuse a defendant's expert of clairvoyance, this is how you do it. And federal prosecutors, they don't exactly love to have their name out there, so I'm not going to attach it. We know who it is, but we don't need to put his. First of all, not that anyone would ever do you know, like, the most dumb criminals, no one ever messes with a federal prosecutor. It's like the ultimate, literally, like, it's like this word on the street. Like, you might mess with a cop, you might mess with a DA, you might mess with a judge. Like, everybody has this, like, understanding. If there's even like a Fed in the like orbit, like, run, like, they got you, like, just run, just don't even try to fight it. Like, they're gonna get you. Don't fight them. Do not bring the fight to them. Don't try to resist. Don't do anything if they come for you. Hope that they give you a deal. That's literally the way the feds are thought of. Nobody touches federal prosecutors. Nobody touches FBI agents. Nobody touches federal judges, and I mean that. Nobody goes near them. Nobody knows where they are. Nobody knows what they do. No one follows them. No one asks them questions in public. Maybe if you saw them walking into a courthouse, but I wouldn't even do that. And I'm talking every person in the press, too. Nobody bothers federal prosecutors. I've never in my life met a human being who had the stones to bother a federal prosecutor. And I'm talking, I've reviewed some intense cases. You can see the wiretaps where the mob guys are like, dude, that's a federal prosecutor. We are not doing that. And the other guy will be like I'm a cowboy. Like, I don't care. And they'll be like, no, like, we'll take you. Like, you will be removed from this equation before we do that. I've seen them say it to bosses, too. And I think the reason for this is there was a time in Italy where they were doing this to judges, like, in that country. So the U.S. set up this very robust, like, I'm talking, you do that to a prosecutor or a cop, they come for, like, the grandkids you don't have yet. That's what I've heard. I've never seen it. I've kind of seen it, but I've just never seen, after the 80s, I've never seen anyone even try it. Ever. It's like this, it really is a fascinating and very important structural function of the U.S. justice system. They're almost seen as like night stalkers. Like, they come for you, you can't escape. Which is good, like, but it's got to be aimed at the most dangerous, which they're doing in right now up here. They're actually, I mean, to the credit of the FBI director, Director Patel, they are doing this around the country right now. They are hitting corrupt politicians, people who hurt kids, people who traffic women, people who traffic drugs, like Fent in particular. Look at what they're hitting. They know what they're doing. They're doing it on purpose. They have a lot of power, but that's the thing. You need that much power. Local government, local and state government cannot go after this kind of power. It requires the feds, and they're very good at it. But they gotta be allowed to do their thing. So it requires this whole political apparatus lining up to give them. They have a lot of power, but they gotta be allowed to use it. By the way, this has nothing to do with Brian Fogarty writing a really good, like, analysis of why Matthew Farwell's expert is not a psychic, but it is relevant to why federal prosecutors are the only people who can solve society's most complex and dangerous problems. And I've always believed that in my heart.
The government. Therefore, the government is entitled to examine Dr. Andrews'
All right,
qualification. Taken at his word, he can know the effect government counsel had on involved why his so far unidentified anecdotal experience qualifies him to draw conclusions about what other medical examiners have done in other cases that do not involve Dr. Andrew. Ultimately, Dr. Andrew claims to offer a remarkable opinion. If taken at his word, he can know the effect government counsel had on a medical examiner without participating in the interaction or identifying the clues he pieced together to gain that knowledge. If he can do this, it would be an extraordinary ability. Therefore, the government is entitled to examine Dr. Andrews' qualifications and learn about what must be a unique methodology. To that end, the government requests a Daubert hearing, at which the government intends to ask Dr. Andrew to identify 1. The cases in which he has been subject to pressure by prosecutors seeking to cause him to change his determinations as to cause and manner of death to suit their theory of the case. 2. The names of the prosecutors who allegedly pressured Dr. Andrew to change rulings. 3. The basis for Dr. Andrews' conclusion that his experience, if any, is consistent with the experience of other medical examiners. And 4. Importantly, the methodology or process he uses to divine the application of pressure applied to any other medical examiner without observing the interactions between that medical examiner and any prosecutor or other member of law enforcement. 2. Witness tampering is not the proper subject of expert testimony. Putting aside the fact that Dr. Andrew has yet to explain his ability to know that a medical examiner's decision was the product of improper pressure from law enforcement, this phenomenon is not the proper subject of expert testimony. Qualified expert witnesses generally may offer opinion testimony if that testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. United States v. Pires, 642 F. 3rd 1, 12, First Circuit 2011, quoting Federal Rule of Evidence 702. Expert testimony on a subject that is well within the bounds of a jury's ordinary experience generally has little probative value. On the other hand, the risk of unfair prejudice is real because it can put the expert's stamp of approval on the party's theory. See United States v. Montes, 41 F. 3rd 775, 784, First Circuit 1994. Here, Farwell claims Dr. Andrews' opinion is simply a logical deduction from the nature and timing of the meetings. ECF number 224 at 12. Expert testimony does not assist where the trier of fact has no need for an opinion because it easily can be derived from common sense, common experience, the trier of fact's own perceptions, or simple logic. See United States v. Zajankauskas, 441 F. 3rd 32, 39, First Circuit 2006, quoting 29 Charles Allen Wright and Victor James Gold, Federal Practice and Procedure Section 6264, 2005. Because Dr. Andrews' testimony is simply a logical deduction from circumstances about which he has no personal knowledge, it is not proper expert testimony. See also Ancuda v. R.N. Fish & Son, Inc., 535 F. Sup. 2nd 170-174, D. Me, 2008. A statement of the obvious, which is within the ken of a lay jury or a judge presiding at a bench trial, is not a proper subject of expert testimony. 3. The court should exclude Dr. Andrews' opinion under Rule 403. Farwell claims that Dr. Andrew will not challenge Dr. Capo Martinez's professionalism. ECF number 224 at 12. Instead, he intends to point the finger at government counsel. Idea. However, Farwell has no actual evidence or good faith basis to claim that the government did anything improper during its meetings with Dr. Capo Martinez. All Farwell has is Dr. Andrews' apparent willingness to speculate, albeit wrongly, about what the government did during meetings Dr. Andrew did not attend. At trial, Dr. Andrews' testimony will mislead and confuse jurors. Federal Rule of Evidence 403. That is because Farwell will use Dr. Andrews' opinion to argue specific facts about what happened in this case that neither Dr. Andrew nor any other witness can establish. 1. The government did something improper during the meetings with Dr. Capo Martinez, and 2. It caused Dr. Capo Martinez to change her ruling. Therefore, even if the court were to conclude that Dr. Andrews' testimony satisfies Rule 702, his testimony is inadmissible under Rule 403. See United States v. Tetyukine, 725 F. 3rd 1, 6, First Circuit 2013, holding, even if expert testimony passes the requirements of Rule 702, it remains subject to Rule 403's balancing test. Federal Rule of Evidence 403. 4. Respectfully submitted, Leah B. Foley, United States Attorney, by /S/Brian A. Fogarty, Brian A. Fogarty, Elizabeth C. Riley, Torre, B. Cummings, Assistant United States Attorney's Certificate of Service. I hereby certify that this document filed through the ECF system will be sent electronically to the registered participants as identified on the Notice of Electronic Filing, NEF, and paper copies will be sent to those indicated as non-registered participants. /S/Brian A. Fogarty, Brian A. Fogarty, Assistant United States Attorney. Date, August 26, 2026. 1. This is not the first time Farwell has made this unsupported allegation. At the detention hearing, Farwell argued, and the Office of the Chief Medical Examiner's opinion has not changed despite the fact that the government has met with that office on at least 2 occasions in an attempt to get them to change their opinion, and they have not swayed. ECF number 134 at 9. 2. Farwell's counsel met with Dr. Capo Martinez on June 10, 2026. Farwell has not produced any reports reflecting defense counsel's interactions with Dr. Capo Martinez during that meeting. 3. Farwell may cross-examine Dr. Capo Martinez to explore the basis for the revised ruling. See ECF number 187 at 9. 4. The government has observed that some of Farwell's arguments have been imbued with unsupported allegations that counsel is acting in bad faith or even misleading the court. See, for example, ECF number 134 at 5. The government shouldn't use their bail memos to mislead the court, the public, and the press about the evidence in this case. These allegations are neither true nor are they a necessary component of the adversarial process. The government's view is that allegations of professional misconduct are serious and should be based in fact.
Oh yeah, they've upset the government. All right, ladies and gentlemen, my name is Grant Smith Ellis. I've brought your favorite Towel Channel mascot, his name is Peep, over to say hello. This is Peep, all right? He just wanted to come over. I have to go to bed. I'm on a strict towel bedtime, not just because Towel Girlfriend thinks it's important for my health, which it is. Because I'm already disabled as it is. It could get worse. Second, I have to get up very early, okay, to go cover the big Proctorgate hearing at Norfolk Superior Court. It will be live on this channel, youtube.com/@GrantSmithEllis. Now, if you learned something, let me restart. If you found today's content helpful, if you'd like to support these efforts, there's a bunch of different ways you can do so. My name is Grant Smith Ellis. You've been watching youtube.com/@ you've been watching Towel News, youtube.com/@GrantSmithEllis. Clearly I'm tired and I need some sleep. If you want to support these efforts, there's ways to do so. There's a Cash App money sign Grant Smith Ellis. There's a Venmo at Grant-E1. There's a PayPal, paypal.me/Grant Ellis. By the way, 876 of you voted, almost 1,000 people. And I asked, are you ready for 2 days in a row of Proctorgate hearings? 83% of you said, yes, Towel, I'm here for it. 6% of you said I am running around in circles. I hope you've since stopped. If not, you've definitely you've tired yourself out. 6% of you said, Towel, I brought the goats. Excellent job. And 5% of you said, I have turned into an actual towel. Well, I mean, it was 5% of 900. That's like 50 of you who have just become a fabric, which, I mean, more power to you. But there's other ways to support. As I mentioned earlier, I have a book out now. Did you know that? I have a book. You can find it at Amazon. It's quickly rising the Amazon charts, so your support at this moment would be great. Please do not donate or buy the book or anything like that if it'd be a burden. I'll get you a free copy. I can drop that in the chat at any time. Also, if you would like to support, you can. There's a towel store. God bless all of you. I heard a lot of the items are coming in. I haven't even had time to show you some of the items. I can't wait to show you the picture of Bunny in the apron. Actually, you know what? I think I might have it. Let me see if I have it. Hold on. Everybody hold. Everybody hold. Everybody pause. Everybody pause. Are you ready to see what the apron looks like from the towel store? It's the greatest thing you've ever seen. Kofi, prepare. Kofi, this is your moment. Where is it? Where is it? I saved it the other day. Hold on, I'm going to go get it now. Kofi, this is your moment, okay? Yes. Yes, Bunny is going to be up on the screen. I did get permission. It's not a full, you won't see Bunny, but it's the apron, okay? This is the moment you have all been waiting for. Yes, I made this apron It is my book. We put it together on stream. Well, not all on stream, but it's months of research. And then I made it into an audiobook. And then I took the audiobook. Well, I wrote it all up, and I made it into an audiobook. Then I took the audiobook, then I made it into a Kindle. So it's not available as an audiobook yet because that I want to read. I want to have someone do the voice if we're going to do an audiobook release. Right now, it is only available as a Kindle publication, which I made myself. So I did that by hand. I did all the chapters. So yes, it is my book. It is climbing up the Amazon charts. Oh, here it is. I found it. I wrote a book. I can tell you the name of it. Please do. Oh, I can't tell you the name of it. That's funny, Silent Dogs. My book, ladies and gentlemen, is called Boss Tweed Days in Norfolk County, The Rise and Fall of Michael Morrissey's Machine. Now, here it is. Are you ready for this? Listen, I don't know if you all are ready for this. I am. Okay? I was born ready. Okay? Here is Bunny. Hold on, where is it? Where is it? Here is the apron. Okay, Kofi, try to contain your excitement. Are you ready to see Bunny's apron? Ladies and gentlemen, look at the towel apron. Look, that's Peep. This is his first time seeing himself on an apron. I mean, look at him. He's like, what? Is that me? That's you, Peep. You're on an apron. So that's the apron. Isn't it a great apron, ladies and gentlemen? Look at it. Look at that Bunny towel apron. That's Bunny wearing Bunny on an apron. Yes, this is the moment. And look how great that apron looks. It wears very well. You can cook things. You can just walk around. Oh, Bunny is cooking with this apron on at this moment. Is it a good apron for cooking? I hear it's very nice. It looks great. It came out great. The colors look awesome. They really filled in the details. And on these ones, I'll show you how to get it in a second. The bunny's teeth, okay, and eyes match the color that you pick for the apron. And it has 4 pockets. You don't understand. It has 4 pockets. Yes, many pockets. No, nothing like a lot of pockets. So you might be saying to yourself, well, sir, I didn't know that your name is Towel Van Away. How do I get this amazing apron with your model bunny towel? Kofi's losing it right now. Kofi knows that his mom is on the TV. He is having a moment, all right? This is one of those moments he's going to remember forever. Now, you might be saying to yourself, how do I get this amazing apron that Bunny Towel Mom has modeled so graciously for us? You can go to towelnewsnetwork.com, or you can go to the link in the chat, okay, which is at Bonfire. They'll both bring you to the same place. Towelnewsnetwork.com is the easiest way to get there, all right? When you get there, you're going to see some different options. Now, they're all great. A lot of people like the tea towel. The tea towel is bigger than you think. It actually hangs over an oven. It's really cool. The sweatshirt, those ones are also awesome. Tiffany Bob has a great pink sweatshirt. People like those. The Run shirt just came in. The first ones of those came in. So, yes, Silent Dogs. How, Grant? Tell us. I'd be happy to tell you. Oh, thank you, Journalism on YouTube. That's wonderful. The hoodies, Tiffany Bob says they're very comfy and amazing. Silent Dog says, do I have XSL hoodies? Are they cotton? Well, let's find out right now. So, if you go to the That's It, I'm Mad design, you can find that, yes, we do have 2XL hoodies, and you have your choice in 2XL of yellow, charcoal, pink lemonade, Paragon, or sand. Personally, I like the yellow one. Okay? And in terms of the fabric info, they are... This soft pullover hoodie has a relaxed fit. It's made from a blend of 80% ring-spun cotton and 20% polyester. This is a heavyweight shirt with a soft feel. The exception is soft gray, sport gray, which is 75%, 25% ring-spun cotton poly blend. Okay? And you can take a look at the measurements there. So, yeah, there you go. Apparently they're very soft. Now, if you want to get the apron, I know a lot of you are like, yeah, but I want the apron. I saw the apron. I love the apron. Well, you just click the apron. All right, 2 of them. Bunny Towel Mom is a twin. By the way, I made this item. I don't sell them. You buy it through Bonfire, read the terms, caveat emptor. I just gave them a license. But take a look at this. This is the apron. You go into the apron. Now, there's only one size, okay? you saw Bunny Towel Mom. This is what the apron will look like. Okay, it's a good apron. Excellent apron. One of the best. You want to go in here. Now, you can pick which color you want. All right? They all have the same pockets, all the same fabric and material. Okay, you can pick dark gray. Now, Bunny Towel Mom, I don't know if she picked burgundy or red. I think that looks burgundy. All right, that one came out really, really nice. Now, they will fill in. As you can see, there's no white under that M. Okay, they filled that in there and made sure it printed right. All right, and everything's looking really nice. So you can figure that out. And that, if you're wondering what the apron's made of, it is 100% heavy cotton canvas. All right, so the apron is 34 inches in length, 28 inches in width. One size fits most. It is 100% heavy cotton canvas. It features a front pouch pocket, stitch into compartment. All right, self fabric waist ties, an adjustable neck band knot with large metal eyelet details. Okay. Is that Ron Burgundy? I love it. Yeah, so you all overall, ladies and gentlemen, thank you all so much in so many ways for your support. I let you know how you can get the book. I let you know how you can support Towel. I'm really grateful for you. This is Pete. He's our Towel Channel mascot. I have to end. I got to go to bed or I'm going to be all cranky. You don't want me trying to cover this thing tomorrow tired. I won't be functional. So, as we approach 6:13 p.m. Eastern here in Boston on Wednesday, August 26, 2026, it is 12:13 a.m. in South Africa, 1:13 a.m. in Tel Aviv, Israel, and 1:43 a.m. in Tehran, Iran. That would be Thursday, August 27, 2026. Now, we have a tradition on the stream. At the end of streams, we like to do covering live. Tomorrow, I'll be live. Oh yeah, we'll be live. We will be live. My motion is approved to cover tomorrow's hearing at 9 a.m. All right. Judge Krupp approved it himself. Anytime Judge Krupp and Towel cross paths, whether it's a motion on a desk or in person, it's always an experience. Judge Krupp did approve my motion, though, so I will be there in person. The stream will start at 9 a.m. on this channel, or as soon as court goes into session. And I will have a very high-quality camera, and hopefully I got it refurbished for a great deal. I'm very grateful. And we'll use that in the future for other coverage as well. Now, we have a tradition on this stream. It's called Tippecanoe and Tyler 2, with Triple Bob and others. It's 11:13 in the UK, 11:13 p.m., or 23:13, as they say. We have a tradition on this stream called Tippecanoe and Tyler 2, where I list the U.S. presidents to test my mental acuity at the end of stream while hanging out with the Towel Channel mascot. His name is Pete Bunny Towel. All right. His origin story is fascinating. He was abandoned. I adopted him 12 years ago. I actually gave him to my mom as Mother's Day gift. She didn't want him. She abandoned him. I took him in, put him on a bookshelf, and like 3 years ago, he became the Towel Channel mascot. He's a good Pete. He's a good man. He's not an animal, but he is fluffy. All right, so that's it. Here we go. President Washington, President Adams, President Jefferson, President Madison, President Monroe, President Adams Jr., President Jackson, President Van Buren, and William Henry Harrison. I don't know 10. 11 and 12 are Tippecanoe and Tyler 2, so it's going to be Polk, Taylor, Tyler. Then it's going to be 13 is Millard Fillmore. He's an odd duck, no pun intended. You know what I'm saying? And then we go into Pierce Buchanan, Lincoln Johnson, Grant, Rutherford, B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William R. Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. How about them apples? You know what I'm saying? Yeah, I took in Pete, though. We became friends. You might have lost a frame or two during Tippecanoe and Tyler 2, but that's okay. Good job, everyone. I'm proud of you all. I was speaking really fast there. Any moment now. Let's go. Are we back? There we go. Sorry about that. So, I hope you caught all of Tippecanoe. Triple Bob's here for Tippecanoe. I love it. God bless you all. Thank you for being with me. Thank you for supporting Towel News. And if you really want to pay it forward today, if you learned something today, I strive to educate, inform, and entertain. 20% entertainment to insulate your brain from trauma, 40% information, 40% education. If you want to pay it forward, do consider a small act of service and kindness for those around you today. You may consider something like donating to our homeless veterans or service members or their families. There should not be a single veteran or homeless or service member homeless in the United States of America against their will, or we have failed as a society, ladies and gentlemen. They fought for our freedoms, the freedoms that enable us to do what we do every day and hold this country accountable and build a better tomorrow. They are the foundation of that work. You can give back to them today and help me ensure that the number of homeless veterans and service members in America within the next 5 years drops to 0. Because against their will, they want to live in the woods, we're not going to stop them. They get survival skills, all right? But if there's a single veteran or service member homeless against their will in the United States of America, we have failed, and I will work to bring that number to 0. We can do it collectively. Now, what if you like our furry friends and our service members and veterans? Have you considered donating to an animal shelter or charity that helps our service members or veterans or is run by our service members or veterans? Great way to help our furry friends. Great way to help our service members or veterans. Now, if you can't find such a charity, you can donate to an animal shelter or charity in general. Our furry friends can't speak for themselves. They're defenseless. We adore them. So, in that regard, do consider a donation to an animal shelter today. Now, if you're in the UK, you may consider a donation to The Big Issue. It's a great way to help populations experiencing homelessness in the UK. They can't yell out on the street corner anymore, but you can consider a donation to The Big Issue today. It doesn't have to be a donation, though. It could be something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while, or even giving away 200 tomato plants like Francis Futrell did one time, and having them designated honorary during the outro forevermore. Yes, in that way, ladies and gentlemen, may we continue to pray that the current realpolitik shifts from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love. They are in allowing us to live up to our Tau Eudaimonia, or Summum Bonum, our greatest good in the ancient Greek or Latin respectively, and in turn bringing about a new digital epoch defined by Aquarius the water bearer, standing tall and carrying a Peabody towel. I believe it's possible because of you all. God bless you all. Thank you for being with me today. Thank you to each and every one of you. Thank you for being you. God bless all of you. God bless these United States of America. And, in turn, this thus concludes very intense, very information-filled broadcast day on Towel News. Find more from me, youtube.com/@GrantSmithEllis. Have a blessed rest of your day, afternoon or evening, whatever the case may be. My name is Grant Smith Ellis. Thank you again for watching. Thank you for being you. God bless all of us. God bless these United States of America. May God keep and protect all of you, and may God keep you safe. Until we see each other tomorrow at 9 a.m., signing off for now, Grant Smith Ellis and Bunny Towel. We love you all dearly. Thank you for your support. Thank you so much. When I have some time to slow down and reflect, I'm sure it will be very overwhelming. But in this moment, no, it is not lost on me, and I am grateful to God, first and foremost, but also to all of you. God bless you all. Good night.